Good morning, ladies and gentlemen. Welcome to this conference on shaping appropriate ADR in international law, a conference organized by the ILA Committee on ADR in International Law, and also under the auspices of the Italian branch of the ILA, ILA Italy, which we warmly thank. But thanks go first and foremost to the Department of Law of the University of Florence, who is kindly hosting us in this beautiful venue. And I will immediately leave the floor to Professor Olivia Lopez Peña, who will welcome you on behalf of the department.
Thank you, Serena. I'm here also on behalf of the director of the Department of Legal Science, Professor Irene Stolzi, to welcome you, and I'm very pleased and honored to host this seminar because it's very interesting, a matter new, if we want to go in the topic, and we will discuss, as you know, shaping appropriate ADR in international law from a various perspective, as I noticed from the program. It was for the department an honor to decide to host and accept the proposal which come from Serena Forlati to host this seminar in Florence, and we wish also to repeat. We can repeat in future, I think, the same formula, and so we can, I think, start with our session, the first session. And so I again give the floor to Serena, I think, for an introduction to chair the seminar. Thank you.
Thank you very much, Olivia, and thank you also for all your help in arranging the practical aspects of this event, which we really wish to be an in-person event. I should mention the fact that the committee has been meeting mostly online, and that we did feel that there was a need for an opportunity to discuss face-to-face, and also to engage with the broader scientific community dealing with the ADR in international law. This is the reason why we published our call for papers, which had a really unexpected success. We received a lot, really tens of very interesting proposals, and it was a tough job to select among them those who would be presented here. I should also mention that we used also among our criteria for selection the availability of the speakers to come to Florence in person, and we are arranging a number of online seminars for some, at least, of those who could not come to Florence. So at least part of those events will be public, so just keep an eye on our announcements for the next months. I should also warmly thank my co-chair, Amy Porges, who's sitting beside me, and also all the members of the scientific committee who helped us in the organization of the conference. And last but not least, the local hosts. I have already mentioned that, and the Italian branch of ILA for helping us also with some practical aspects and sponsoring us. I should also mention the fact that we have had some very last-minute changes in the program of this morning's conference. Unfortunately, two of the speakers had to call off at the very last minute. Angela Ha of Voltaire Lafayette and Professor Malkawi of the University of Arizona could not make it to Florence and do not have the possibility, for serious reasons, to present even online. So we have a slight alteration of the program, and we have had the fortunate opportunity to insert at the last moment a third speaker, nonetheless, in the morning panel, the first panel, Justice Anthony Gafour, who is also a member of our committee, and he will give a presentation on the Guyana-Venezuela border dispute later this morning. I am really grateful to him for his availability to step in with such short notice. But all this said, I would just like to give the floor to the first of our speakers, who is Dr. Yoshinobu Takei. He's Associate Professor of International Law at Keio University, but also has significant experience in the field of the law of the sea and ocean policy, including with the United Nations Office of Legal Affairs and at the University of Utrecht and the Ocean Policy Research Foundation in Japan. He's also been active in the World Maritime University in Sweden and the Fridtjof Nansen University Institute of Norway. He will discuss with us a rather interesting topic, the potential of ad hoc expert panels in resolving disputes under the BBNJ agreement. Please, Yoshi, the floor is yours. You have 15 minutes, but given the fact that we have one rapporteur less, I can be a bit lenient with time, but still we want to have space for discussion. So please, the floor is yours.
Thank you very much, Serena. I hope everybody hears me clearly.
Yes, everything is fine. Thank you.
Perfect. Good afternoon from Tokyo, and indeed good morning to you at the conference venue. Well, let me first thank the organizers of this conference for allowing my remote participation. As I understood, it's in principle it should be in-person attendance, but unfortunately the conference organizers allowed me to remotely participate, and well, of course, it's a pity that I cannot participate in person, but nevertheless, it's a great pleasure for me and honor for me to speak at this conference online. So today, I will be presenting a paper entitled The Potential of Ad Hoc Expert Panels in Resolving Disputes Under the BBNJ Agreement. Well, just for the information of those who are not too familiar with the law of the sea, the abbreviation BBNJ Agreement means the agreement under the United Nations Convention on the Law of the Sea on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. This is the third implementing agreement to the UN Convention on the Law of the Sea, and it was just adopted in 2023, and it still awaits entry into force. So in my paper, I argue that there are limitations and opportunities in the ADR provision of the BBNJ agreement, focusing on the issue of ad hoc expert panels. These limitations, in my view, could be possibly overcome if parties to the agreement through the Conference of the Parties COP succeed in advancing the necessary arrangements for the panels. The topic of the implementation of the BBNJ agreement is particularly timely now. The BBNJ agreement, as I mentioned earlier, still needs 39 parties before it enters into force. However, the preparatory work for its entry into force is already underway. Indeed, the first session of the BBNJ Preparatory Commission is scheduled to take place from next week. It is therefore very timely to assess the potential of the agreement, including its dispute settlement provisions from the perspective of ADR, and consider what needs to be done when it enters into force. A point of departure for our discussion today is UNCLOS, the UN Convention on the Law of the Sea of 1982, which sets out the international legal framework for all activities in the oceans and seas, and sometimes called a constitution for the oceans. UNCLOS is equipped with a comprehensive dispute settlement system, including compulsory procedures entailing binding decisions, in addition to non-adjudicatory means of dispute resolution. For some of the issues that fall outside the jurisdiction of UNCLOS tribunals, States are entitled to unilaterally refer the dispute to compulsory conciliation as well. What is interesting about UNCLOS dispute settlement is that although UNCLOS as such does not explicitly refer to technical disputes as a separate category for dispute resolution, it contains a provision that allows participation of experts in UNCLOS tribunals without vote in disputes involving scientific or technical matters. Following the entry into force of UNCLOS, mechanisms for the resolution of technical disputes have evolved quite significantly. The UN Festox Agreement, which was adopted in 1995, and indeed this is the second implementation agreement, generally provides for the mutatis mutandis application of the UNCLOS provisions when it comes to dispute settlement. However, it also contains a new provision on ADR in the form of the ad hoc expert panel. Article 29 of the Festox Agreement, entitled Disputes of a Technical Nature, provides as follows. Where a dispute concerns a matter of a technical nature, the states concerned may refer the dispute to an ad hoc expert panel established by them. The panel shall confer with the states concerned and shall endeavor to resolve the dispute expeditiously without recourse to binding procedures for the settlement of disputes. There are 5 elements that characterize the panel. Firstly, it is an optional and consensual mechanism. Secondly, the output of the panel is recommendatory in nature. Thirdly, it emphasizes to address interstate disputes. Fourthly, the panel is expected to address technical disputes. And lastly, this procedure is additional to the existing binding procedures and not intended to replace these procedures. The ad hoc expert panel enshrined in the UN Festox Agreement has never been invoked in practice. However, its provision has developed through regional fisheries management organizations, RFMOs, in subsequent years. The panels in these RFMOs vary considerably. Some RFMOs incorporated the provision of Article 29 of the agreement and even developed additional types of panel mechanisms to strengthen decision-making at these RFMOs. And indeed here, I should note that there is another article of the UN Festox Agreement that might be related to the ad hoc expert panel. That is Article 28, as you see on the screen. As a background, I should also mention that some RFMOs allow their members to object to the adopted conservation and management measure and opt out of such a measure. As you might imagine, this is a very problematic issue because the free rider would undermine the effectiveness of the measure adopted by the RFMO in question. And indeed, this is a very significant problem because on the high seas, all states are entitled to the freedom of the high seas. And if someone does not comply with the measure, then that state is in principle free from that measure, legally speaking. And that is why the UN Festox Agreement calls for addressing this problem. And indeed, this is the issue which was taken up by these RFMOs. As you see on the screen, many areas of the world's oceans are now covered by RFMOs with the ad hoc expert panel. Some of these panels, which I call review panels, are established after the lodging of the objection by a member and review the conservation and management measure in question, as well as the compatibility of the objection with the requirements under the RFMO constitutive instrument. In these RFMO review panels, one of the characteristics is that RFMO themselves become party to panel proceedings. In other words, instead of interstate disputes, the panels address a dispute between the objecting state and the RFMO, which represents the collective interests of the organization and its member states. In the Law of the Sea, there are some issue areas that allow international organizations other than the European Union to participate in proceedings as parties, such as the International Seabed Authority in the context of dispute settlement, in the context of deep seabed mining. The ad hoc expert panel in the context of fisheries provides an additional opportunity for international organizations' participation to ensure the integrity of the regime. As exemplified by the UN feedstocks agreement provision, the outputs of the panel are normally non-binding. However, in some cases, they have some legal effect and restrain the behavior of the actors concerned. In one RFMO, the South Pacific Regional Fisheries Management Organization, the review panel has been established 3 times so far and has contributed to preventing the undermining of the effectiveness of the measures in question, without recourse to binding procedures. Well, now let me turn to the central issue for my presentation today. That is the BBNJ agreement. The agreement, as I mentioned, was adopted in 2023 and addresses a diverse range of issues. Among the issues addressed, there are 4 main elements. These are the marine genetic resources, area-based management tools, including marine protected areas, environmental impact assessments, and capacity building and transfer of marine technology. And there are a number of cross-cutting issues that are also addressed in the agreement. The BBNJ agreement also contains a provision almost identical to the UN feedstocks agreement on the ad hoc expert panel, as you see on the screen. So basically, except for the very minor linguistic changes, the relevant article is identical. However, it does not contain any provision on the strengthening of regional mechanisms. As you see on the right side of the screen, the article called Prevention of Disputes also exists, but the part which deals with decision-making at the regional level has been deleted. So indeed, the relationship between the agreement and regional and sectoral institutions, bodies, and frameworks was one of the most contentious issues throughout the negotiations for the BBNJ agreement. Okay, then would the ad hoc expert panel under the BBNJ agreement be able to contribute to expeditiously resolving disputes without recourse to binding procedures? My observation is as follows. As for the ad hoc expert panel for interstate disputes, the parties may wish to consider preparing detailed rules of procedure for the establishment of such a panel through COP. A more critical question is whether such a panel is actually useful given the collective interest to be protected by the agreement. So then, what about different types, new types of ad hoc expert panels, such as review panels? In the BBNJ agreement, there is indeed a provision that allows parties to object to decisions on area-based management tools, such as marine protected areas. The one crucial omission is that there is no explicit link between this ad hoc expert panel under the BBNJ agreement and the objection procedure. In other words, although the objection procedure for area-based management tools under the BBNJ agreement is constrained, for example, by limiting the possible grounds for an objection and requiring the adoption of an alternative measure, the agreement does not envisage the review of the measure or its objection by the panel. This omission is no coincidence. The objection procedure was inserted at the last minute towards the end of the negotiations with a view to reaching consensus among negotiating states, which were very divided on this issue. Therefore, if a future COP agrees to establish a review panel, a careful balance should be struck in finalizing the BBNJ. A careful balance that was struck in finalizing the BBNJ agreement needs to be maintained. Another issue that needs to be considered in assessing the role the ad hoc expert panel may play is the relationship with other bodies and mechanisms under the BBNJ agreement. The first one is the dispute settlement procedures. So as I mentioned, the BBNJ agreement is equipped with dispute settlement procedures, including compulsory procedures entailing binding decisions. During the negotiations, there were various proposals to depart from the system established in UNCLOS, but in the end, the relevant provisions adopted were quite similar to UNCLOS in substance. If the panel is merely for the expeditious settlement of technical disputes between states, the panel is just an optional addition to the binding procedures, which means that its utility is rather limited. To the contrary, however, if a third-party review from a technical perspective is realized by the panel, then that would be a valuable contribution. The second issue that needs to be considered is the potential request for advisory opinion by ITROS. And indeed, the COP is entitled to request advisory opinion from ITROS. And this is useful, especially to address issues that cannot be reduced to interstate disputes. However, given the expertise available among ITROS judges, it would be questionable whether this is appropriate for decisions on disputes, the core of which relates to technical matters. And thirdly, and lastly, what needs to be considered is the implementation and compliance committee under the BBNJ agreement. This committee is to be established to facilitate and consider the implementation of and promote compliance with the provisions of the agreement, and shall be facilitative in nature and function in a manner that is transparent, non-adversarial, and non-punitive. On the basis of this wording, it is not clear whether this committee is suited for resolving disputes. In this regard, panels such as review panels would have a distinctive role to play, even though the matters which the committee and the panel deal with may sometimes overlap. In conclusion, as we have seen, the ad hoc expert panel under the BBNJ agreement can play an important role in resolving disputes distinct from other dispute settlement mechanisms. But before being able to do so, it still needs some work through the conference of the parties. At the moment, and on the basis of the provisions of the BBNJ agreement, it appears that there are obstacles that prevent the panel to work effectively. It is, however, to be seen what the conference of the parties will determine. Like many multilateral environmental agreements, the BBNJ agreement is not intended to be a static instrument, but rather it is expected to be an evolutionary mechanism. It is rather expected through COP and other bodies under the agreement to develop over time. In that regard, the findings in my paper demonstrate that ADR provisions such as the ad hoc expert panel under the BBNJ agreement have the potential to contribute to the achievement of the objectives of the agreement. Thank you very much for your attention, and I'm more than happy to answer any questions you may have. Thank you very much.
Thank you. Thank you very much for this fascinating presentation, which really gives a glimpse not only on the BBNJ, but also on the impact of expert panels more broadly in the area of the law of the sea and fisheries management. I think this is really an interesting insight. I wonder, I was thinking of having the discussion later, but given the hour in Japan, maybe if you prefer, we can have the discussion on your paper now so that you are free to leave whenever you wish. Maybe this could be also because there is no real there is no direct connection between your presentation and those who come later, So maybe we open the floor now on this presentation, and the floor includes, of course, those attending online. So let's hear if there's any questions. Those online should raise their hand, and we will admit them and open their mics. Yes, and Yoshi, could you please take out this presentation, the slides, so that we can have a broader view on the screen? Any questions, please? Would you please come here so that you can be heard from a distance? There is a mobile mic. You can stay there. And please, those taking the floor, could they say who they are before putting their questions? Well, yeah, sorry. You should come here because of the mic. You need the microphone. That is, the mobile mic is not here, so that is a problem. Yeah, it's going to be coming, but
You can have it.
yeah.
Me.
Okay, yeah.
At this point. Thanks. I want to thank the speaker. I think it's a really good topic to start with because of the proliferation of negotiations on climate-related matters. So this has come up in the plastics negotiation, for example. So, and it seems highly likely, given the state of international relations on economic matters, that ad hoc arrangements should be facilitated rather than taking everything to formal state-to-state dispute settlement. And I note in that my background is in the international trade area. Actually, a lot of disputes in WTO are settled on a very informal basis through the committee structure. So you have to look at, if you just look at formal published opinions, it's not there. There's a good article by Petros Mavroidis, I think, on that. Anyhow, thanks.
Thank you very much. Any other comments or questions for our speaker? Please, Amy, yeah, you take that mic.
For Professor Take, this is Amy Porges. So the question is, to what extent does the compliance committee of the BBNJ agreement or other fisheries agreements, to what extent does that provide a mechanism for ADR? And if not, why not?
Would you like to respond now to these first comments? Otherwise, I can raise a few more issues, but please.
Sure. Thank you very much indeed. So the compliance committee, there is a compliance committee under the BBNJ agreement, and indeed that is separate from the part dealing with dispute settlement. And the compliance committee, I believe, is more in the nature of facilitative, and it is not expected to actually attempt to resolve the dispute. And indeed, there's one issue relating to the composition of the compliance committee, where in some multilateral environmental agreements, the compliance committee is composed of individual members who are indeed representing well, they are participating in private capacity. On the other hand, some other agreements take the form of compliance committee consisting of member states. And in the case of BBNJ, this issue is still to be discussed, and it is one of the issues that needs to be addressed during the first conference of the parties. So if the compliance committee becomes a more individually composed entity, then it might be possible for the committee to take a decision which is separate from the collective decision making by the conference of the parties. But if the compliance committee is composed of the member states, then I think the committee perhaps cannot be regarded as an independent, impartial entity which can review the measure adopted and indeed contribute to the dispute resolution. When it comes to fisheries matters, regional fisheries management organizations, RFMOs, many of them indeed have compliance committee. And sometimes these committees are very useful in pointing to the breaches of the convention constitutive instruments. And on the other hand, these compliance committees tend to be less effective, I would say, when it comes to address the violations by states themselves. So they are effective in terms of revealing the violations by individual vessels, but not states themselves. Because, again, the compliance committee in many cases at the RFMOs are composed of the member states themselves. So then the ad hoc expert panel of any kind would be useful because of the independent nature of the panel. These panels are able to not only address issues arising from the behavior of member states, but also by the issues relating to the decisions of the collective decisions of the member states. And if indeed, if there is any violation of the constitutive instrument by the conference of the parties of these regional mechanisms, then that can be addressed by the review panel. And indeed, I should, well, because of the time constraint, I didn't go into details, but the South Pacific Regional Fisheries Management Organization has indeed succeeded in pointing to the discrimination made by the Commission when it comes to the objection by the Russian Federation. The Russian Federation made objections twice, and these objections were led to the establishment of the review panels, and the review panels indeed pointed to the discrimination done by the Commission, while indeed pointing to the fact that the measure adopted was not the alternative measure adopted by the Russian Federation was not in line with the provisions of the convention. So, in these examples, the review panels were able to address the violations of both the Commission and the objecting party. And this is, I believe, not something that can be done by an organ of the organization because of the membership. Thank you. I hope that answers to some of your questions.
Thank you very much. I wonder if there's any other question from the audience here or from online participants. Otherwise, I have a question or a couple of a comment and a question, but I don't see any hands raised. So my observation is that I am not an expert in the law of the sea and least of all in fisheries management, but I must say that I am completely in agreement with you as comes to the role of compliance committees. Their composition matters very much in terms of the kind of role they play. And I wonder, at least in other areas that I'm more familiar with, an issue has also arisen as regards the publicity, at least of the outcome of their work, and also the work of expert panels. And I wonder how that aspect is dealt with and settled in the framework of the agreements you were reviewing, especially the BB&J. The second observation, maybe, well, second question really has to do with something that you hinted to, the fact that there might be the chance or the potential for these expert bodies to actually, if I got you right, maybe I didn't, step in a moment where actually fully fledged dispute has not yet arisen. Do you imply that they could play a role in preventing disputes from actually arising? And how do you see the relationship with the dispute settlement function that they could also have? Thank you so much.
Thank you very much indeed. These are very, very pertinent questions and comments as well. So let me start with the first question about the outcome and the publication of the outcome and related issues. And indeed, the South Pacific Regional Fisheries Management Organization, which I mentioned, has been served by the Permanent Court of Arbitration in their procedures, in their proceedings 3 times. And indeed, everything, everything I should say public, is available on the website of the PCA. And PCA is very good at arranging all the documents, including the findings and recommendations of the panel, as well as submissions by the organization and its members available on the internet. And indeed, this is well under the title other interstate proceedings, I believe. And so it is clear that it is not an arbitration, but instead it is an ADR procedure. But like arbitration proceedings dealt with in the PCA, under the PCA auspices, all of the documents are available, and these are very useful, not only for researchers, but also for those dealing with the issue in practice. And indeed, I should perhaps also mention that the review panels have been composed differently, but there is a series of overlaps between the panel members. So there is some kind of consistency among these review panels, which make the recommendations more convincing, because they are all building upon the previous findings and recommendations. The second issue, which relates to the timing of the intervention by the expert panel, ad hoc expert panel, as I understand, in principle, these panels will be established when there is a concrete dispute. But the perception, the identification of disputes as such depends on how the member states perceive whether or not these disputes arise. And indeed, in the course of fisheries organizations, it was always the case that the dispute is identified to have a reason when there was an objection or there was the adoption of the measure. So there was a clear kind of critical timeline. But when it comes to BBNJ, it is not yet clear. And I think, again, this is an issue that needs to be considered by the Conference of the Parties when the agreement enters into force. Thank you.
Thank you very much for your excellent presentation and also for this very interesting discussion. I don't see any further questions, so I would now give the floor to the second speakers because this is a joint presentation by Professor Paula Almeida of Getulio Vargas Foundation Rio, and Dr. Lucas Völlers, also from the Getulio Vargas Foundation in Rio. They will speak about a nuanced approach for assessing ADR's appropriateness in the Americas, navigating between law and politics in the Brazilian legal external policy. Thank you so much, Paula, for being here in person, and thank you, Lucas, who will make part of the presentation remotely. And also for being up at a very awkward time of the day for you. Paula, the floor is yours. You will start, as far as I understand. Yeah.
This fine. You hear me?
No, you need to switch it on. Yeah, that's it.
That's okay. And Lucas is going to put it in the screen. Yes. Okay. So thank you very much. Thank you, Serena, and thank you all the organizers for having us here. Well, our presentation today, together with my colleague Lucas Völlers, intends to assess ADR's appropriateness in the Americas. So this is navigating between law and politics. And thank you. And our objective is to assess whether there is an appropriate ADR mechanism which could be adapted to the context of American states, and in particular of Latin American states. So in order to answer this question, we intend to analyze whether the existence of institutional mechanisms, be they multilateral or bilateral, dictate or influence somehow states' recourse to ADR. And also to identify other criteria that could play a role and could guide states' decision to choose any of such dispute resolution mechanisms.
Sorry to interrupt, Paula. Lucas, we are not seeing the slides. So
now, yes.
Now, yes, but it's not in presentation mode. So if you could manage to go to full screen. Not yet.
Now they're not there.
Yeah.
But by the time he puts there, I can keep going.
Yeah,
because
going.
But we have 20 minutes in total?
Yeah.
Okay. So our research departs from the idea that international disputes frequently intertwine political and legal considerations as a consequence of a strategy, context, or power dynamics. States strategically engage with international law to advance their national interests, and this according to their foreign policy, or what we called, because we borrowed the expression from La Charrière, the politique juridique extérieure. So our general point relates to the choice and appropriateness of ADR mechanisms within international law, which is, of course, contingent upon the broader political context, and is also intrinsically related to foreign legal policy objectives and strategies. So there is a constant attempt in many international treaties to distinguish between diplomatic and adjudicatory means to settle international disputes. Dispute resolution mechanisms, they usually display a dichotomy, diplomatic or political means on the one hand, and adjudicative means on the other. And this distinction between political or diplomatic means as opposed to adjudicatory means is visible in the Hague Conventions from 1907, and also in several conventions adopted in the Americas, such as the Pact of Bogota, which is the objective of my presentation today. However, no doubt remains that legal disputes submitted to courts are also embedded in complex political scenarios, which makes it very unclear to draw a clear-cut line between the political context and legal disputes. For instance, if we take the example of territorial disputes, defining them as legal or political seems to be a failed exercise, because all interstate disputes, they are also by definition political. So this evident connection has also been recognized by the ICJ in the United States Diplomatic and Consular Staff in Tehran, and reiterated in the Wall Advisory Opinion from 2004. And so the determination of the choice and the appropriateness of a dispute resolution strategy or mechanism is therefore dependent upon a complex interplay of political and juridical factors. And this can be cited, such as the willingness of the parties to engage in a cooperative resolution, the capacity of national governments to manage domestic repercussions, the compatibility between domestic legal norms and also international legal norms, the potential for escalation to violence in the absence of a settlement, and the commitment to bear costs associated with maintaining the existing state of affairs. And in this context, the decision to activate a specific ADR mechanism seems to be strategic, and also depends on other factors which can be directly or indirectly related to the dispute, such as the subject matter, the identification of the disputing parties involved, the selection of a specific court for initiating proceedings to the detriment of other courts, the priority given. The priority given by states. I think I managed to. Thank you. To diplomatic relations with the other parties, and also the desire of some states to retain some control over the outcome of the dispute, which is notably the case in the Latin American continent, and the availability and accessibility of dispute resolution mechanisms. So this reality is, of course, applicable to Latin American states, as opposed to the general idea that was in the report, according to which dispute resolution in public international law has traditionally centered on adjudicative means with a focus on judicial means. Latin American states, they have historically opted for arbitration and the use of ADR due to their flexibility and their capacity to maintain a relationship with other sovereign states in the region. So the second part of my presentation will discuss ADR mechanisms in the Americas, with a particular focus on the Pact of Bogota, which is the regional framework dedicated to the peaceful dispute resolution. And this pact is very interesting to study because it reflects two main features of Latin American international tradition, which is the commitment to peaceful settlement of disputes, which can be traced back to the Congress of Panama, and a strong support for the ICJ during the elaboration of the statute after the First World War within the Committee of Jurists, and including the support for the automatism of the court's jurisdiction. But during the second half of the 19th century, it was arbitration that became the preferred method of peaceful settlement among American states, as a series of several border disputes were submitted to arbitration, and then they were successfully resolved. For example, in 1890, several arbitration agreements were concluded concluded, and they give rise to multilateral treaties adopted later on, providing for arbitration and notably on other means of dispute settlement. In the 90s, several treaties were also concluded by American states, and they all provided access to good offices and to mediation, conciliation. Some of them created investigation commissions with a conciliatory function, mixed commissions, among others. So in the late 1930s, several regional and bilateral instruments dealing with the resolution of international disputes were concluded. However, there was so many instruments, so many treaties, the means they provided for the peaceful settlement of disputes were highly dispersed. So this is how this idea of having one single document started to resonate among decision makers. So the draft instrument that was going to form the basis for the Pact of Bogota was submitted to the Conference of American States in Bogota in '48. And the conference committee replaced the compulsory arbitration procedure by a compulsory one, but providing recourse to the ICJ for the first time. This was really an innovation because compared to other treaties in the Americas, none of them was providing access to the court, and none of them provided ever, recourse to judicial means, because they were all based on arbitration and on ADR methods. So the last point I would like to address here concerns these ADR mechanisms as provided for by the Pact of Bogota and the limits. So my point here relates to the procedure that was formulated by the Pact of Bogota, and this procedure was frequently criticized for being very inflexible and for ending up by jeopardizing the potential of ADR mechanisms provided in the Pact. The Pact today, well, today we can have 15 American states part of the Bogota, because some of them have already left the Pact, and it establishes a coordinated system for dispute settlement. And it also provides a lot of details for the implementation of ADR mechanisms, citing expressly, for example, good offices, mediation, commission of investigation and conciliation, and it also provides a mechanism for arbitration and compulsory jurisdiction before the ICJ. But all the other treaties, bilateral ones or multilateral ones, the one that I was citing before, they all cease to be in force for the states who decided to be part of Bogota. But however, a far great number of disputes, if we compare, a far great number have been settled outside the Pact of Bogota than those who were settled under its provisions. So there is just one example that we could map regarding the use of ADR in the Pact with the provisions from the Pact of Bogota, and this is a dispute in Central America. And in this case, well, all the cases, not only in this case, but also in the other cases leading to ADRs not necessarily based on the Pact of Bogota, they all depended on the recommendation of a political organ of the Organization of American States. So this context specifically occurred between Costa Rica and Nicaragua over border incidents in 1955. And these two states were recommended by the political organ of the organization to create a commission of investigation and conciliation in accordance with the Pact. And apparently, and this is what we have in terms of data, is that the commission contributed to the successful resolution of the conflict. And we have some academic works telling us the way it worked, and also some based on some documents publicized, which were published at that time. So despite several provisions for ADR, concrete examples of their explicit use under the Pact of Bogotá really remain scarce. And this is maybe due to some, maybe two main reasons, if I may. Do I still have time? Yeah, I think you can. Great, thank you. So the first one can be related to the point that was already advanced here, which stems from the preference for political means of dispute settlement in the region, as Latin American states have traditionally opted for the political means for settling their disputes. And this is also something that is recognized in the Rio Treaty, which provides also for consultation, which was conducted by the Permanent Council of the Organization of American States. And also in the procedure as adopted by these political organs of the Organization of American States, in the auspices of what we call we called at the time Inter-American Peace Committee. And this Inter-American Peace Committee offered good offices and also conciliation procedures. And it was later on integrated into the OAS charter and became a subsidiary organ of the Permanent Council, and was entitled afterwards Inter-American Committee on Peaceful Settlement. But this committee in 1985 was eliminated because the OAS charter was amended under the Protocol of Cartagena. So the main point here relates to the complementarity of both political means and legal means for the settlement of disputes. And it is often criticized and said by Latin American states, notably, that they should not be mutually exclusive. They could work together and be activated together. And the second point concerns the need for a more flexibility to resort simultaneously to adjudication and non-judicial methods of dispute settlement. This was also advanced by some practitioners and also by some academics in the region, to say that the Pact of Bogotá is very rigid, because they advanced this argument saying that this is very rigid because the rules, they include some principles. One of them is the prior exhaustion of diplomatic negotiations under Article 2, and also the principle of electa una via, right, under Article 4, and in other words, the obligation not to pursue two procedures of dispute settlement at the same time. So the ICJ has confirmed this requirement in the case regarding border and transborder armed actions between Nicaragua and Honduras. And we can recognize that if this principle of electa una via is aimed at preventing the multiplication of several disputes or efforts or venues, they seem not to be effective, and it has been criticized for its lack of effectiveness, taking into account this necessary interplay between judicial and non-judicial procedures. Because most disputes possess components ranging from legal, political, and economic and social aspects. And the ICJ has also recognized these other aspects of a dispute when it held that it had jurisdiction over the legal aspects of military and paramilitary activities in and against Nicaragua. Therefore, the parties could also be involved in ADR mechanisms. And the point is that this should not prevent the ICJ from exercising its jurisdiction. And this is because parallel settlement involving non-judicial and judicial means, this do not appear to be ineffective. Yes, Lucas has to speak, of course. So in other situation, negotiation took place, and we have other examples in which the case was initiated before the ICJ, but then in the middle of the case, at negotiations, they restarted, and these negotiations could be concluded by the conclusion of a treaty, such as the Esquipulas Agreement, which led Nicaragua to ask for the discontinuance of the ICJ proceedings, right, and the merits. So just to finish, what could be expected to serve as a real prominent framework for ADR has in practice become more used to give access to the ICJ as a compromissory clause for litigation before the court. And the reasons are maybe outlined here, the ones that I mentioned, not only regarding the paucity of ratification of the Pact of Bogota, but mostly related to these limits that were outlined in the pact. So Lucas is going to present examples of dispute resolution methods applied in the Americas and presenting a case study of Brazil's politique juridique extérieure. So thank you very much for your attention.
Thank you very much, Paula. Lucas, you have the floor, please.
Okay, so just jumping right into Professor Paula's points, I just want to briefly highlight some of the final parts of our presentation, the final section in which we provide some practical case studies for Brazil's foreign policy regarding the use of ADR. And I mean, I'm just going to briefly highlight some of these instances because what it seems most interesting is to see how the lack of the reference to a treaty-based solution, such as the Pact of Bogota, as Professor Paulus just mentioned, Brazil used several mechanisms, such as suggesting mediation, suggesting the institution of commission of inquiry and conciliation, suggesting treaties which propose recourse to arbitration. So in the conflicts, in the disputes, interstate disputes, which we analyze in this third section, there are several instances where we found that there was a multiplicity of forums. For instance, in the Chaco dispute between Bolivia and Paraguay, there was a proposal of solution in the League of Nations, but also within the framework of inter-American relations, using the US and Brazil and Argentina as mediators. In the Cuban crisis, for instance, the use of the OAS framework was broadly used. However, no direct reference to the Pact of Bogota. In other instances, such as the Contadora peace process in regarding conflicts in Central America, there is also no reference to a specific treaty, so that parties could sort of create a tailored solution without the United States in this matter to provide a specific contextualized solution to their regional problems. So, I mean, I'm not going to detail every case in this chapter, but I would just like to highlight some of these conclusions, which sort of try to assess what factors were behind Brazil's decision to use or to propose one or other ADR mechanism. So there are some examples we can address here. So specific parties perhaps involved, as Professor Paulo said, also the specific nature of the dispute, the legitimacy of the third party, which is very important in our research because sometimes Brazil is seen or is not seen as a legitimate party for some specific dispute, the location of the use of these ADR mechanisms, such as a mediation conference or a direct negotiation. This is also interesting. And also the procedural guarantees of good faith in negotiations were also a common topic. So also just to end here my talking points, arbitration is usually used for a neutralization tool for territorial disputes in Brazilian foreign policy. So sometimes there's a dispute territory and Brazil will engage in negotiations with this opposing party so that this territorial area is neutralized, and then this issue is settled by arbitration. And also, regional context, as Professor Paulo said, is always context specific. So there's always a solution which is most likely going to be legitimate if it's conduced conducted using regional actors and regional platforms, such as the OAS, for example, and also the Pact of Bogota. As I said, the Contadora process highlights the importance of using specific actors and not always opening discussions for all regional actors. And the use of presidential diplomacy is also very important in the Cenepa war between in the 1990s. There was a critical role of Brazilian presidential diplomacy of Fernando Henrique Cardoso, which proved also an effective form and a specific form of negotiation as an ADR mechanism. So also the use of guarantor states in treaty solutions and bilateral treaty solutions has also been a solution, an idea to provide a peaceful solution to regional disputes. So without further ado, this was what I had in mind for these topics. So if Professor Paula wants to comment on something, it's always welcome.
Maybe just one thing to add. Perfect, Lucas. It's just the difficulty that we had in finding these cases. You know, the second part of the presentation. Lucas did not go further into details on all the cases, but we cited them from A to G. So diplomatic negotiations, Chaco, Letícia Fair, Cuban crisis, Contadora Group, Cenepa conflict. So we cited just one of these, but to show you that this was based on work on diplomatic, documents, and we went further, not legal, because we couldn't find it in legal academia or books. So it was really difficult to map these cases and to present them to you.
I think we can discuss this further in the question and answers part of the session. But now we have a third speaker who we warmly welcome. He is speaking from Malta, Justice Anthony Gafour, who is Chief Justice of the Tax Court in Trinidad and Tobago and a member of our committee, an expert in mediation and arbitration. And he has kindly accepted to step in to discuss the border dispute between Guyana and Venezuela, although he's also presenting in Malta at another conference today. We see him on the side, I think, of the... Can you hear and see us, Anthony?
The presentation really focuses on the significance of Guyana. And this dispute is really considered one of the most contentious and long-standing territorial disputes in the Western Hemisphere, because the Guyana-Venezuela border dispute really encompasses a vast region known as the Essequibo, or as the Venezuelans call it, Essequiba, representing approximately 2/3 of Guyana's current territory. So this presentation really looks briefly at the historical origin, the political significance of this dispute, and of course, more importantly, the legal dimensions of the dispute, particularly from the ADR perspective. And I think it should be said that one of the more significant factors which was probably lend some impetus to this dispute are the recent oil discoveries in Guyana, which have intensified the conflict. And of course, this has in many ways entrenched Venezuela's position in terms of its claim to the Essequibo region. So this process, this dispute really goes back to 1841, when there were Spanish colonial claims to establish the initial territorial boundaries, and this laid the groundwork for future conflict. So this is not a new conflict, it's something that goes back to 1841. But the most contentious really arose in 1899 with the Paris Protocol Award, which settled the border and granted disputed territory to British Guyana, which, so, as its name suggests, it was under the control of the British at the time. Now, this subsisted from 1899 to 1962, when Venezuela formally challenged the law, claiming corruption, procedural irregularities. Justice decided the claim to find a memo authored by a member of the tribunal after his death, which claimed that there was some level of bribery and corruption involved in the determination of the arbitral decision. And this has continued right up to the present. And it was mentioned this area, the under dispute, encompasses 159,000 kilometers of territory comprising 2/3 of Guyana.
Anthony, I am afraid we really don't hear much here. I don't know whether you can use headphones or find a way, because we hear half of what you're saying, and it's really not
Is this
spoiling the
is this better now?
It is better, but I think there's a big echo. I think there might be a second connection that you're using. So if you switch the
Yes,
other out.
if you can take off your wrap, it will be a lot clearer.
So not good. You should have only one mic on.
Yes. I think
Okay, now.
Yeah. Better now?
Better now. Yes.
Okay. Thanks. Okay. So I mentioned that really that has a significant historical antecedent, and typically the concerns about 125,000.
Switch off Indira's connection. I'm sorry. There are two connections. Yeah, and
are you able to switch it off from your perspective? Because it doesn't seem as if I can. I think this is causing the problem.
okay, let's now try now. Speak.
Okay. Hello. Anybody?
Hmm.
No. So problematic. Right.
We already did that. Try and speak now. We did it from our side.
Okay. Hello. Is it better?
I think it's better, but you need to speak directly in the mic if you don't have headphones. Otherwise, we won't hear you.
Okay. All right. This is right. It's better now?
No, you need to switch
Okay.
the mic for Indira. We have done that. Don't switch it on again, please. And maybe speak now. Let's try.
Yes. Okay. All right. Let me try to proceed with the legal dimensions of this dispute. Is that any clearer? Yeah. I mean, if you're able to eliminate Europe from the contributors, that would probably help. I can't seem to be able to do it, unfortunately. Let's just see.
And yeah, maybe that's, but we.
Okay.
Anthony, please go on.
Okay. I seem to have lost the screen now altogether. Oh gosh. Okay.
Yes, but if you keep the other connection with the screen, probably we just don't hear you. So I wonder whether you can make the presentation without.
Yeah, I'll do that. All right. So that I'm deeply apologetic for this. I'll have to send the slides afterwards. All right. So that in terms of the modern status of the dispute, we can trace this to March 2018. When, because of the ongoing dispute with Venezuela, Guyana eventually filed a case with the International Court of Justice. And then back in December 2020, the ICJ confirmed jurisdiction despite Venezuela's objections. And in December 2023, the International Court of Justice gave a ruling which ordered Venezuela to maintain the status quo and refrain from altering Guyana's control. That didn't quite work, but there was an intervention by the Caribbean community where one of the prime ministers of the region from the country of St. Vincent managed to get the two conflicting parties together and sign something called the Argyll Accord, which was to maintain the status quo. Of course, more recently, with the ongoing legal proceedings, Venezuela has been stepping up its continued demand for the claim to the Essequibo region. And in fact, I think it even withdrew the map of Venezuela to include that region as part of its sovereign territory. So Guyana has continued to seek a definitive resolution now through international law, and Venezuela has continued to largely reject the International Court of Justice's jurisdiction. And this has created a very complex legal environment whereby enforcement mechanisms remain limited. And so, in my view, this border dispute represents a critical test case for the efficacy of international legal institutions in resolving long-standing territorial disputes, particularly where significant natural resources are at stake. So Venezuela has engaged, as mentioned, in several provocative actions. Of course, some may see it differently, but they held their own referendum back in December 2023, which claimed that there was 96 to 98 percent support for the claim to the Essequibo region, despite there being a low voter turnout. And in fact, that referendum attracted significant international criticism. Then they engaged in legislative annexation of the disputed territory and passed domestic law formally designating the Essequibo region as a Venezuelan state. And as mentioned, created a new political map, issuing Venezuelan identification cards to residents. And then it also went on to announce intentions to immediately begin oil exploration and natural resource extraction in the region, directly challenging existing international contracts. So Guyana had also issued various contractual arrangements with some international firms engaged in oil exploration. And of course, some of them have been hampered by Venezuela in continuing their exploratory efforts. So these somewhat unilateral actions by Venezuela have escalated tensions significantly. And President Maduro's government has taken increasingly assertive steps to solidify its claim, moving beyond mere rhetoric to concrete administrative and military preparations. And these provocative measures have raised international alarm about the potential for this dispute to evolve from a legal disagreement into more direct confrontation. However, Venezuela's economic and political challenges have potentially increased the domestic incentives for territorial expansion. So where we are now is that the United States has reaffirmed its commitment to protecting Guyana's sovereignty and its firm opposition to the Maduro regime and its attempt to unilaterally annex the disputed territory. Brazil also has been making active mediation efforts and deployed its military to border regions as a precautionary measure. And then we've had various regional organizations, the Caribbean Community being one of them, the Organization of American States being another one, and other regional bodies which are expressing concern and have been offering, over a period of time, diplomatic support. And the UN itself, Security Council's involvement, and Secretary General has called for peaceful resolution. So the international community has responded with increasing concern to the escalation of tensions. And Brazil in particular has taken an increasingly active role in mediating discussions while simultaneously reinforcing its military presence in the region as a precautionary measure. As mentioned, the United States, particularly since the Trump government took office, has explicitly backed Guyana's position, while multilateral organizations have called for peaceful resolution through established legal mechanisms. So one of the interesting things that's emerged from this case study is that previous ADR efforts in its various manifestations, whether through negotiation, mediation, or arbitration, have really not resulted in a solution that I think both parties can live with. Something that perhaps wasn't formally alluded to in the paper that was circulated, but I think is worth mentioning, is the UN Good Offices process, because again, this is another important mechanism to resolve ADR disputes and something that was attempted here as well. And so this dispute really points to increasingly a demand for creative conflict resolution strategies. And it also highlights the significant limitations in traditional ADR mechanisms, because despite decades of diplomatic initiatives, mediation attempts, and the UN Good Offices process, sustainable progress has remained elusive. So these challenges really stem from fundamental incompatibilities in the parties' position, domestic political considerations that inevitably have complicated any attempted compromise. and the absence of enforcement mechanisms outside of formal legal channels. Of course, even if the ICJ renders a decision which may be seen in favor of Guyana, there may be issues of enforcement which has arisen, and which of course arises in any matters concerning a decision from the ICJ. Of course, almost inevitably, what has continued to spur the conflict, and there is a graph that you will get in due course, demonstrates the significant impact of the oil and gas exploration to Guyana's economy, which has been increasing exponentially. And I think that continues to spur this dispute into a live issue. One cannot also forget, and particularly when it comes to issues of investor dispute, the impact on the population, because 15.8% of the population is indigenous, with distinct cultural traditions and territorial connections predating colonial boundaries. So, for example, the Amerindian tribes have been used to moving quite easily between Brazil, Venezuela, Guyana, without any hindrance. Of course, now that may be a little bit more challenging. The indigenous communities also have established territorial claims based on ancestral occupation and traditional land management practices. Again, that sort of community dimension, which is critical for ADR. And then, of course, the importance of cultural preservation of language, practices, and traditional knowledge. So these are issues that are often overlooked in geopolitical analyses and, of course, in the forms of ADR that perhaps many of the members of the committee and others in attendance may be used to, because it's absolutely critical to take into account the issues pertaining to the indigenous communities, right, and preservation of their cultural heritage. So what are the international law considerations arising out of the dispute? One is, of course, inevitably the territorial integrity of Guyana, and of course, the forcible acquisition of territory, which would point towards maintaining existing boundaries. And it seems as if the international community generally favors Guyana's position based on decades of effective administration. There, of course, continue to remain historical claims where Venezuela's argument rests on pre-independence boundaries and alleged procedural flaws in the 1899 arbitration. And then there are also concerns about the precedential effect, the precedent that is being created by this dispute, particularly which needs to balance the question of adjudication generally, and of course the enforceability of the arbitral award. So these principles and these issues engage fundamental principles of international law, including territorial integrity, the binding nature of arbitral awards, and the concept of uti possetis juris, which is the maintenance of colonial era boundaries. These principles often come into tension when historical claims conflict with contemporary realities of territorial administration. And so the ICJ's approach to this case may establish significant precedent for resolving similar disputes worldwide. Of particular interest is how the court balances or will balance the respect for historical arbitration with claims of procedural irregularity raised by Venezuela, and how it addresses competing interpretations of colonial era documentation and establishing contemporary sovereignty. So we're at this situation now in terms of potential scenarios where we have the question of escalating tensions, including increased militarization and confrontation. Hopefully somewhere in between, there's still the possibility of a negotiated settlement, but ultimately, the global environment, and particularly the two conflicting parties, may have to rely on the ICJ for final resolution. Whether or not Venezuela will respect the ICJ's decision may depend on the intervention of the international community. So these scenarios, I think, certainly point to continuing conflict and possibly escalating conflict, even possibly after the ICJ ruling. And we don't necessarily have a formal date yet when that will be delivered. Less optimistically, we can see the continued rejection of international legal mechanisms, particularly by Venezuela, which could lead to sustained uncertainty and even military posturing. And so while outright conflict remains probably unlikely given international engagement, the possibility of heightened tension disrupting regional stability cannot be dismissed entirely, particularly as economic states continue to rise with further resource development. So in conclusion, what we can see is that international law remains as a firm foundation in this dispute because robust legal frameworks remain essential for the peaceful resolution of territorial disputes despite enforcement challenges. There's also, I think, the important lesson of collaborative approaches, whereby there is hopefully continued scope for innovative conflict resolution strategies, which have to balance the historical claims, contemporary realities, and resource management. And then, of course, we must not forget the human rights dimension, that solutions have to prioritize the needs of affected population, particularly the indigenous communities with deep territorial connections. And so, therefore, this border dispute between Guyana and Venezuela exemplifies, in my view, the complex interplay between historical legacies, resource competition, and international legal frameworks. So as this situation continues to unfold,
Anthony, sorry, I think we need to wrap up because we need to have a few little space for discussion.
I'm in the process of concluding. As this situation continues to unfold, it offers important lessons about the strengths and limitations of current dispute resolution. So how do we move forward? Moving forward, I think the international community must support approaches that respect sovereignty, protect human rights, and enable sustainable development. And I think the ultimate solution or resolution of this dispute will not only determine the future of this disputed region, but may also establish important precedents for addressing similar conflicts worldwide. All right, that concludes my presentation. Thank you very much for your attention.
Thank you so much. When we could hear you properly, it was very, very interesting, and you raised many complex issues that are really worth discussing in assessing the role of ADR. But once again, I open the floor for the two presentations. Any questions, observations from the audience? Please, Facundo, I think you need to come. Yeah, the mic is working. Yeah, now.
Hello. Well, thank you very much for the very interesting presentations. I have a question for Paula and Lucas. Well, it's a comment and a question. The comment is the following. Some time ago, I did a research on Mercosur and ADR in Mercosur. And the funny thing was that Mercosur provides very specific ADR mechanism, but as you said, most of the disputes are settled outside the system. Actually, directly between Brazil and Argentina mostly. So the problem when I was looking for the disputes was the same. I had to look in the news in order to know what was settled by the government. So my question is, do you think there is a way to amending this in Latin America, or we should just leave it like that? Thank you.
Maybe we could collect a few more questions and then give back the floor to the speakers. You have a question?
A question.
Yes.
A question. Well, I just wanted to know if you, for Anthony, what are the prospects of the second provisional measures request by Guyana in your view?
And I also, yeah, that's my fault. I also have a comment on Anthony's presentation, and also on Paula and Lucas. The first one on the latter on their presentation concerns this issue of difficulty in finding reliable information. This is a problem throughout ADR, I think. And we have discussed within the committee that there is a need for a balance there. Which kind of balance is a question mark, but it is a very common thread, I think, when one explores ADR. To Anthony, I think you pointed out very well how judicial and non-judicial ADR proceedings actually mix, and also to the relevance of ex post ADRs, even though the ICJ has not pronounced itself in a final way so far. But ADR, in terms of implementation of judicial pronouncements, is also a very important aspect. The question here being that whenever there is a very strong political will by one of the parties not to comply, no matter the instrument that you will have, even judicial instruments have their difficulties there. But yeah, I will just give back the floor, maybe first to Anthony this time, and then to Paola for your answers.
Yes, thank you very much. No, I think you have encapsulated very, very well the conundrum posed by this dispute, because one of the challenges is that while one always hopes that ADR, and indeed the paper referred to appropriate dispute resolution, which I think is also a very significant term here, points to really upholding the 1899 tribunal award. It was really only something that emerged, as I mentioned, back in the 1960s when Venezuela reopened this issue. But I do think that we see the very significant interplay between ADR and judicial mechanisms, which points to the fact that neither is exclusive, that they can work or should work in tandem. And I personally think it's a pity that things have reached as far as they have regarding the ICJ dispute. And one dimension that I haven't really emphasized is, again, the differences in strength between, a large country like Venezuela and a relatively small country like Guyana, and that inequality of bargaining and so on. But I think with the balance of the international community, it favors, I suspect, ultimately upholding the 1899 arbitral award. But time will tell which way the ICJ will rule on it.
Thank you. Paola?
Oh, thank you, Facundo, for this great question. Yes. Well, what we see nowadays is that we have mechanisms provided for by treaties, for example, in the Mercosur, and also in the Pact of Bogota, and they were not used and the way they could be used or have been used. But the issue in the Pact of Bogota is mostly related to what I was mentioning, because they wanted really to separate things, and this was a very inflexible way to approach disputes, and maybe and this has been advanced in some attempts to reform the Pact of Bogota, but none of these attempts have been successful, and which means that I really feel that we could also motivate an extended use of these mechanisms via the Pact of Bogota. But maybe what we are witnessing more nowadays is the use of ADR in other agreements, such as we mentioned yesterday, some trade agreements. For example, the Mercosur and the EU bilateral agreement. There is a chapter on ADR on several mechanisms, and notably the part regarding sustainability. So maybe not directly the Pact of Bogota, if it doesn't have prospects of change or amendments, but maybe going directly through bilateral trade agreements and trying to motivate their use, because there's a lot of clauses there. The one from Mercosur, but also the one from Chile, between Chile and the EU, and you can see, they all possess these types of ADR in their structure. So one idea would be to use another avenue and maybe explore the potential of these bilateral agreements. And I don't know if I wrote something else. In any case, we see that, of course, we can have this strategy of trying to institutionalize possibilities, but we know that in practice, some of these uses of ADR will never be institutionalized. So, of course, we can institutionalize, but we could also raise awareness in other ways, and not necessarily providing this in a specific treaty. I think yeah, because we found in our research that it's exactly the practice that is showing us that not every mechanism needs to be institutionalized. So I think in both ways, maybe motivate or use and institutionalize in bilateral treaties. Lucas, I don't know if Lucas has something to say on this.
No, I'm happy with your responses. Just what I'd like to add that, yeah, sometimes states or a coalition of states choose to use a certain mechanism because they feel like they have some sort of legitimacy to resolve this specific dispute, and sometimes they resort exclusively to negotiations and bilateral negotiations mainly because they think they don't want to publicize a dispute or they don't want to put more political pressure or in a sensitive topic. For instance, just to give you one example, in the Venezuelan crisis situation, there was a few years ago the Lima Group formed by some of more liberal states in Latin America, and they try to propose this group as a specific forum for addressing some disputes in a ADR format. But then suddenly some political changes in the continent, and the Lima Group was no longer a sort of adequate or appropriate forum for this discussion, and then it turned back to the OAS and some sort of more bilateral or multilateral discussions, negotiations, really. So it really depends. It's really context specific. So it's hard to give you a precise answer on that. So just to complement Professor Paulo's answer.
Thank you so much. Thank you, everybody. We are at the end of this session, and we can now have a break until 15 past 11, and we will resume later on. For those present here in Florence, there's a coffee waiting for us. And the first item for our discussion is actually a presentation of a new editorial initiative of ILA Italy. And on this, I give the floor to Professor Alberto Malatesta, who is Secretary General of the Italian branch and also editor of the new journal. Please, Alberto.
Thank you, Serena. Thank you for giving me this opportunity to present our new yearbook, the brand new ILA Italy yearbook. And I have to say that I'm especially proud and happy to do it today here, at least for two reasons. The first, because it's a nice coincidence, because the yearbook will appear online tomorrow. So your meeting brings luck, if I may say. And hard copies are about to be circulated in a few days. So this is the first reason. The second reason is that it's a nice opportunity to do so on the occasion of a meeting of an ILA, of an international committee. Especially of the ADR committee, whose members are so much contributed in the first volume, as we shall see in a moment. So a few, let me say only a few words of presentation. A first question obviously arises, and the question is, why a new legal journal? Do we need another legal journal, a new one? The reasons that led us to promote this new yearbook is that we live in a transforming world. It's there to see. And so we felt the need to promote, to provide with instruments to safeguard the international legal regime on the one hand, but on the other also to highlight the developments and the structural changes, if any, if we can say that, are facing such changes. And the idea, the perspective of our yearbook is to do so through the peculiar lens of the ILA work. We intend to do so through the work of the ILA committees, whose ultimate goal is indeed to promote peace and international cooperation. So in a word, to bridge the gap, if I may say. It's not necessary to recall that the ILA international committees, like the ADR one, strong influence over many areas of international law, from the use of force to human rights, international trade law, tariffs and trades, and so on. So the idea is to start from the work of the committees, to benefit from their works, in order to focus on and to discuss the topical issues in contemporary international law. That's our perspective. That's our idea. Even if the yearbook will not consist only of a mere collection of judgments, of works, of recommendations, of papers arising out of the committee's works, but intends to become a a forum for debate, between scholars, practitioners, all the people involved in international law, hopefully also decision makers and all the stakeholders involved in international law. So we plan to host contributions and views, not only from ILA members, but also from all the professionals involved in international law around the world. So we welcome contributions and views from the north and the south of the world. The idea is to connect the different parts of the world. So you can see here, maybe we can have a look at the, you can see the cover and the chart of the yearbook. And I would like to thank, of course, all the people involved in the editorial board, especially my associate, my Donato Greco, and all the people who heavily worked in this volume, all the prominent colleagues who agreed to take part in the scientific board. You can read the name over there. Of course, I thank our publishing house, Brill, for hosting us, and all the people who work in the project, including our generous sponsors, some international legal firms, and I would like to thank especially Gianni Origoni & Partners, a law firm based in Milan, as well as Watson, Farley & Williams, who generously supported the first volume, the first initiatives. But I am happy to announce that some others, law firms, international firms, are ready to join us for the next initiatives, for the next volumes. So I'm happy of this. We are happy for this first success, let's say, of our initiatives. Now, I'm glad to give the floor to Serena, who will explain maybe in more details the contents of the first volume, because as I said earlier, the volume, the first volume is mainly devoted to ADR and their instruments, and many of the people involved in your committee, such as Facundo, has contributed in the volume. So I'm glad to give you the floor to continue our presentation.
Thank you, Alberto. Don't worry, I will not discuss the details of every article, but just give you an overview of what you will find tomorrow, when you will certainly be among the first to purchase the essay. I'm joking, but I think it's a really interesting and a productive endeavor. And yes, there is a lot of ADR in it. There are some papers which were the outcome of the conference on ADR in international and EU law we held in Ferrara 2 years ago, and some of them have a direct bearing on the work of the committee. Those dealing with international trade and investment law, I'm sure, will be useful to our co-rapporteurs dealing with those aspects of the mandate. And also those papers which deal with ADR in commercial or more directly EU law, they do not have a direct bearing on the work of the committee, but I'm sure there can be insightful aspects of those papers that can be used as a way of comparing the different dimensions where ADR have a role to play. And therefore, I'm sure we will, as a committee, treasure them. It's 6 papers on the whole dealing with ADR, and I'm sure the focus on ADR will not be as much in the next issues, but for those present here and online, it might be worth looking at. Together with that, the essay also includes, I don't know what, is there another mic that is open, that is closed? Okay, now it's better, I hope. No. There is a lot about ILA and its relationship to international law in the issue. First of all, a number of very short resumes of the works of the committees in which ILA Italy members are involved, but also a very interesting history of the Italian branch by our former president, Professor Venturini, who really gives a very interesting insights about the history of the branch, which is quite old. One of the founders of ILA was Italian, Mancini, and also, even if not formally, but there are records of many meetings throughout the years since the 19th century. So that is something that all those interested in ILA could have a look at. And also there's interesting essays by Luca Radicati di Brosolo and also by a team of younger scholars on the impact of ILA works and ILA committees in different areas of international law, including private international law and arbitration. Looking at how ILA works has been quoted, for instance, in disputes, settlement proceedings and so on. It's also something that is quite interesting and tells us of a world where scholarly societies such as our one can really play a role in enforcing or in emphasizing respect for international law, as is a mandate in our constitution, in the ILA constitution. I will stop here, but would just encourage to have a look at the whole of the volume, including the article by Attila Tanzi, our president, in defense of international law in times of crisis, discussing prospective reforms in the UN, definitely a topical issue today. And also the editorial by Christine Chinkin on women, peace and security, where now, which also gives many interesting and insightful comments and opinions on and elements for reflection on the current state of international relations worldwide. So thank you very much, Alberto, for the support of the branch to our conference today. And I think it's time to give the floor to the panelists, but I hope you'll find it interesting to read our issue. Thank you.
With Facundo? Julia? Julia, yes. Giovanni Chiappa. Okay, you are first. You are the first.
Yeah, I'm the first.
Okay, you are ready? So we can start the second session of the meeting. After we have earlier about interstate disputes, and now it's the time to face at appropriate ADR and disputes between state and non-state actors. And the first speaker is Facundo Perez Aznar from the University of Buenos Aires. So please, you have the floor too.
Well, thank you very much, Alberto. Good morning to everyone, and many thanks for the invitation. It is a real pleasure to be here today. I will present the following topic: consultations and negotiation as appropriate ADR mechanism for investor-state disputes, taking NAFTA and USMCA treaties as case study. But I must admit that there's some echo. I don't know.
Presentation mode. So
yeah, so you can see it. Yeah. But I think it's, you have to if you wanna, I can change the slide.
okay, that's
Yeah.
me that I have to. Sorry.
If you,
Too many devices.
So, well, my presentation is consultations and negotiations as appropriate ADR mechanism for investor-state disputes, taking NAFTA and USMCA as case study. But as I was saying, I'm broadening the scope of analysis in order to cover consultation and negotiations in all bilateral investment treaties or international investment agreements in general. As you know, bilateral investment treaties include investor-state dispute settlement, ISDAs, which includes a period of consultations and negotiations, normally of 6 months, and then the possibility of resorting to investor-state arbitration. This is just an example. This is the Argentina-Austria VAT, which includes the following provision. Any dispute concerning an investment between an investor of one contracting party and the other contracting party on matters governed by this agreement shall, as far as possible, be settled amicably through consultations between the parties to the dispute. And if this consultation do not provide a solution within a period of 6 months, it would be possible to resort to investor-state arbitration. If we go to NAFTA, to the North American Free Trade Agreement, which was in force from 1994 to 2020, it provides also a mechanism of consultation, which includes first that the parties should attempt to settle a claim through consultations or negotiations. Then in the notice of arbitrations, the notice of arbitration should be submitted at least 90 days before initiating an investment case, and it provides as you can see, the requirements that the notice of arbitration should have. For instance, information on the investor, on the investment, on the provisions that are considered breach, and also, well, issues an actual basis for the claim and the damage claim. And lastly, the NAFTA provides that there should be at least 6 months between the event giving rise to the dispute and the initiation of a claim to arbitration. If we put this in a table, you can see that, well, first you have this minimum of 3 months between the notice of intent and the notice of arbitration. You have these 6 months between the event and the notice of arbitration. And you have, this is the prescription clause, you have the claim should be made no later than 3 years between the breach and the notice of arbitration. So these 3 years is the limit framework for consultations and negotiations. And this is the issue I'm covering in this research, this period. This treaty, the NAFTA treaty, was replaced in 2020 by the USMCA, the United States-Mexico-Canada Free Trade Agreement. This treaty replicates the provision on consultations, including NAFTA, with some changes. Well, the first one, most important, is that investment, ISDS is only limited to dispute between Mexico and the United States, not with Canada. Canada prefer to stay outside this system in USMCA, although Mexico and Canada are parties to the CPTPP. So a Mexican investor could bring a claim against Canada, and a Canadian investor could bring a claim against Mexico under the CPTPP. Well, the second difference is that this provision now makes a specific reference to non-binding third-party procedures, such as good offices, conciliation, and mediation. This is something new, but well, apart from the reference in the treaty, so far there have not been more developments on these possibilities. I don't think that there will be any changes considering the political situation between Mercosur, USMCA members, but this requirement now is at least expressly provided in the treaty. And the third difference is that, well, there is an annex specifically dealing with investment dispute related to covered governmental contracts, and for that kind of dispute, the 6 months provision has been maintained, not for the other type of cases. Well, this is some data concerning the settlement of dispute under NAFTA and USMCA agreements. As I said, I'm covering only the settlement of dispute prior to arbitration. So it's the first type of settlements, which normally runs between the notice of intent and the notice of arbitration. And I have found just 12 cases where apparently there was a settlement between the investor and the state. Perhaps there are more cases that were settled prior to arbitration, but we don't have that information because in some situations that information is confidential. And then the second part of this slide shows those settlements after arbitration has started. And as we can see, there is quite an important number of cases that have been settled. From a total of 33 NAFTA concluded cases, there were 9 NAFTA cases settled between the investor and the state, and 14 NAFTA cases discontinued. The cases can be discontinued for different reasons, like lack of payment of the fees of the proceedings or other reasons. But in some cases, the discontinuance was because of an agreement between the investor and the respondent state. Well, now I will move to some legal issues which are quite important, because in order to know how we can settle the dispute by consultation, we need to know which is the nature and the effect of such consultations. And well, we can perhaps make a difference between dispute under BATs and dispute under the NAFTA and USMCA agreements. Under NAFTA, there are different views among tribunals. There is one view that consider consultations procedural requirements that are optional. So the investor can avoid to comply with this requirement because it's just an option. And those tribunals who see consultation in that way normally consider that those consultations are admissibility requirements that can be disregarded by the parties. There is another trend, which I would say that is the modern one, let's say, which consider a consultation as a jurisdictional requirement, which means that it's a condition precedent for the tribunal's jurisdiction, and if an investor does not comply with this requirement, the tribunal does not have jurisdiction and cannot decide on the case. And this follows the latest case law by the International Court of Justice, who has considered this kind of consultation as binding and as jurisdictional requirements. And now turning to NAFTA, in NAFTA, there is, well, the jurisdictional view prevails. There have been some cases at the beginning that consider this requirement as admissibility, for instance, the ETIL versus United States Tribunal, but most tribunals consider those requirements jurisdictional. So if the investor does not comply with these requirements, the tribunal cannot hear the case. And this is the example of the Metanex versus United States case that has been followed by other tribunals. Well, the next slide concerns relates to the purpose of of consultations. If you read the text of the treaties, you will find that the consultations, the purpose of consultation is to settle the disputes. But if you see the practice and the awards by the arbitral tribunals, we can see that the purpose is broader than that. These are just some examples. One tribunal said that the purpose is to allow the parties to engage in good faith negotiations. Other tribunals said that the purpose is to try to reach a solution of the matter before resorting to arbitration. Another tribunal said that the purpose is to grant the host state an opportunity to redress the problem before the investor submits the dispute to arbitration. And another tribunal, and I think this is more comprehensive, said that the purpose is to discuss the dispute with a view to exchanging views over its causes, the interests involved, clarifying factual uncertainties and possible misunderstandings, and identifying possible solutions. So as we can see, it's not just to settle the dispute, but it can be to reduce the dispute or even to improve the dispute in the sense that making the dispute easier for the tribunal to be settled, or to be decided. Well, this tries to respond a question, the question of when consultations are complied with. There is no, of course, a full response to this. There are different tribunals who have different views on when consultations are the requirements of consultation are complied with. But I think at least these points helps at least to understand to some extent when we can comply with consultations. Well, first, are some statements made by tribunals. First, consultations are obligations of means and not obligations of result. The second point is that it should imply a genuine effort to engage in good faith negotiations before resorting to arbitration. Then, well, and here there are more discussions among the tribunals. Well, this is a tribunal in Burlington versus Ecuador, who consider that in order to be effective, consultation have to relate or have to be made by the claimant of the investor who is involved in the dispute, who should allege a treaty breach. So it's the investor invoking the treaty. But of course, this is not undisputed. There are other tribunals who have considered that it's not necessary for the investor to be invoking directly the VAT or even mentioning the VAT in the consultation process. Well, this is another example of a tribunal rejecting jurisdiction because of non-compliance with the consultation requirement. Well, this was the case of a tribunal an investor who submitted a notice of dispute one day, and then the day after it submitted the notice of a request to arbitration. So it was 1 day space between the notice of dispute and the notice of arbitration. Of course, it was impossible to do any consultations in just 1 day, and for that reason, the tribunal considered that it did not have a jurisdiction. Well, and this the last one relates to the good faith obligation. It says that the procedure of good faith obliges state to answer a claim, which means that if there is a claim for consultation and if the state does not reply, then the state cannot invoke the cooling off period, the waiting period or consultation period in BATC. Well, and how this is important, I mean, the legal part of the analysis of consultation provision, because I think it gives some clues in order to comply with those provisions. Because otherwise, it is difficult for the parties to understand what should be the content of those consultations. And I think this has been a real problem in the investment arbitration. Well, now I move to the view of practitioners. And these views were taken from different interviews I undertook with some governmental officials working for different governments within the NAFTA and also outside the NAFTA system. And I think that they are very interesting in order to understand which is the real purpose and the real dynamics during consultations. Well, they mentioned that consultation provide an opportunity for claimants to explain their concerns. They also mentioned that they allow to have a first idea of the claim and of all the relevant agencies involved. And this is quite important for big countries. Imagine countries as the United States or Canada with states or provinces, and sometimes the negotiators, they don't know which were the real problems. So this is the first opportunity to think about the claim in broader terms with the officials involved in the claim. Some interviewees also say that it is difficult to take a general practice. This is in response to a question I have. They said that this is normally not possible to have a general practice because the dynamic of each case varies on a case-by-case basis. They also mentioned that you need some flexibility on the procedure because in some cases it is enough with one meeting, and in other cases you need several meetings with the investor in order to try to settle the dispute. They also mentioned that when a case is launched and it becomes public, it is more difficult to settle the dispute, and this shows the importance that the lack of confidentiality can have in settling disputes under BATs in this period of consultations. And this is also, I think, very, very interesting. They mention also that sometimes negotiation agencies do not have the power to modify legislation or regulation measures. So in those cases, the claim inevitably goes to arbitration. And this relates with the second point, with the accountability issue. Public officials in their interviews mentioned that an agreement with an investor could have legal implications for those officials because they could be prosecuted because of the result of the negotiation. So for this reason, sometimes there is a tendency to go to arbitration. So the public officials don't want to have problems in a way, and they prefer to go directly to arbitration. Then they also mentioned that reaching settlements during cooling off periods is rare. Only in some small amount of cases happen. And they also mentioned that the outcome very much depends on the personalities involved in the consultation. So it is not the same to have to discuss with a reasonable counsel that to discuss with a quite aggressive counsel during the negotiations. Based on this, I think we can perhaps make some suggestions to consultation periods in order to make them more effective. Well, perhaps I think it would be very useful to have more detailed provisions on consultations and negotiation in future international investment agreements, perhaps taking as a model, for instance, treaties with very developed provisions, such as NAFTA, for instance, which, by the way, also includes the obligation for investor to submit a form with specific information on the claim, which in a way standardize the consultation process. It would be also useful to for states to prepare unilateral or bilateral regulations indicating how consultation should be performed in order to be done in a good manner. Also, I think it would be useful for arbitral institutions and arbitral tribunals to promote consultations during the negotiations, prior or after these bodies can intervene, for instance, by developing guidelines, which, by the way, I think would be very useful and is a space we have as a committee involving ADR that we could recommend some guidelines in this sense, based perhaps in part in the interviews used for this presentation. It could be also a reference to consultation in the procedural orders made by tribunals. First, for instance, in the first exit procedural order, a reference to consultation could be useful. And then, and I finish with this, I think, as I said, that it is very important to have in mind that the purpose of consultations, it is not just to settle the dispute, but also to reduce or improve disputes. So if we think consultation in that way, I think we can develop more effective consultations in the investment regime. Thank you very much.
Thank you. Thank you, Facundo, for your interesting.
It's my fault. Yeah.
I will say thank you, Facundo, for your presentation, for your very interesting presentation. Maybe there are some questions from the audience, but if I make, first of all, some comments. I agree with your suggestion. I guess it's your suggestion that the tribunals cannot hear the cases when the parties did not comply with the ADR provisions. That's the new position. But it's quite difficult to understand when consultations are complied with. You mentioned some requirements. I mean, when there is no space at all, no room for talking, for consultation, can we skip the first step, the consultation step, and go directly to arbitration, or not?
Yeah.
I mean,
well, first of all, I think in order for very efficient consultation, it had to be taken seriously first by tribunals, and once it is taken seriously by tribunals, it will be taken seriously by investors, because investors will know that otherwise they cannot resort to arbitration. And concerning the second part of your question, whether it is possible to avoid in some situations complying with the consultation requirement, I think the answer is yes. And for this, you could apply the futility, the principles of futility that have been developed by the International Court of Justice, for instance, and also by some investment tribunals. But I think we have to pay attention not to mix futility under these consultation requirements with futility under the exhaustion of local remedies. There have been some tribunals at the beginning, I would say, that quoted futility in investment arbitration consultation with futility in the exhaustion of local remedies, and I think we have a problem if we assimilate that point.
Yeah. The comparison with commercial cases in this case is problematic. Maybe investor state situations are different from commercial cases. Yes, of course. Are there any Questions, comments from, yes. You want to postpone the discussion? As you prefer. So it's time for our second speaker. Giulio Alvaro Cortesi from the University of Vienna. Yes. So your title is a long title, so you explain us what you're talking about.
Thank you.
Can you hear me?
So first, I want to thank you, Serena, and all the organization to invite me here. I'm very pleased to be here today. And I will draw you into the world of negotiation. Our committee talks about conciliation, mediation. I look at the specific case of negotiation. So my presentation will be in comparison to other presentation, more fact-intensive, perhaps. We will have a look on the renegotiation of geopolitically sensitive investment projects and how a multi-level and creative approach led to party satisfaction in the case of the East Coast rail link. So we will see how we can get out of a deadlock in a geopolitically sensitive project. Next slide, please. So before you is the network of the Belt and Road Initiative. It is a great project that is funded by the Chinese government. The idea is to connect China with the rest of the world, especially mainly with Europe. You see in the north there is a corridor in the Central Asia. Then there is a corridor in Pakistan, and there is a maritime Silk Road that is in the south. As you see, if you take a look at the southern part, next slide, you will see that there is this part that is, there is this red circle. This is the Strait of Malacca. And 1/3 of crude oil that is used by the Chinese industry, so it's quite an enormous quantity passed through this strait, and the large part for import and export of China passed through this strait, especially all the merchandise that is shipped to Europe. So this is called the Malacca dilemma. It was already there during the colonial time, and there is no another easy way to pass this strait, this passage between the Indian Ocean and the South Chinese Ocean and the South Chinese Sea. So this means that if this the strait is closed for geopolitical reason, and that can be the case, you have to consider that from a Chinese perspective, Singapore is not a very friendly jurisdiction. This can be a serious problem from a geostrategical point of view from China. So what happened, next slide, is that state-owned enterprise, not really the Chinese government first, came out with a project, came out with a project that is to build on a railway link from the Kota Baru to the port of Klang on the two sides of Malaysia. And the idea is that in this case, if the maritime road is closed, then you have an alternative, that is this railroad link. And the beginning of this negotiation was very promising because this was a win-win situation, to use a term that the Chinese like and that they repeat in almost all the articles about the Belt and Road Initiative. The idea was to link the east of Malaysia that is less developed to the most developed west part of Malaysia. So it was a good deal for Malaysia, and at the same time, as we saw, it significantly improved the geostrategic position of China. I have now to go to the way they decided to implement this project. I create this scheme for you because it's not very easy to follow it. It took me a while to understand exactly how the corporate structure of the two entities that were involved. So on one side, in orange, you have the Malaysian part. There is this Ministry of Finance of Malaysia. It's the government. Then under this, there is the Malaysian Ministry of Finance Incorporated. This is a sort of state-owned fund that has been created in 1959. And under that, there is the Malaysian Rail Link. And this is an investment vehicle that was specifically incorporated to own and manage this railway and when it would have been built. On the Chinese side, we start from the bottom this time. You see that there is the China Communication Construction Company, is a majority state-owned Chinese state-owned enterprise, is part of a huge Chinese group, and up to that there is the Chinese state, and this the State Asset Supervision Administration Commission on the Council. During the, we could say, the reign of Prime Minister Najib Razak, that was signed this deal. There was not a real tender process. There was not a significant parliamentary involvement in the signature of the two contracts that, as you see, happens at the bottom level. There are two engineer contracts that are signed between the two state enterprises. There is no treaty between the two states, so there is not a significant parliamentary involved. And Prime Minister Najib Razak was also the Ministry of Finance at that time. So this can give you the impression of how this deal was concluded. To go deeper in the structure of this deal, that will turn out important to understand how the dispute then at a certain point came out, is the fact that the CCC construction company came not only with the engineering solution, but also with the financial solution. They have a strong tie with the Exim Bank, that is a Chinese enterprise, that is a Chinese bank, it's a huge Chinese bank that agreed to provide 85% of the funds, and the rest of the 15% of the funds was provided by Sukuks, that is a very specific Malaysian Sharia compliant bond that is granted by the government. So you see the government was involved, but always not very directly. It was the grantor of this part. The two engineering procuring construction commission were signed in 2016 and 2017. Then we move to 2018, and here the dispute starts, and we have general election in Malaysia, and those general election goes very badly for the government in place. A new coalition, the PH government, takes place. It's a leftist wing. It's quite left, not an extreme left-wing party, but is still not really the government that was originally in place. That the former government stayed in place for roughly more than 10 years for sure. So it was quite a particular situation. One of the reasons which fueled the victory of this leftist coalition was exactly the polemics that China was leading. He was using a debt trap diplomacy against Malaysia, and that in order to complete this huge infrastructure, Malaysia would have run into that was never been able to repay. And that was a mechanism to tie Malaysia to China foreign politics. And so the first idea of the new prime minister, the Mahathir bin Mohamad, was to order the suspension of the project. And he ordered a feasibility study on this project, and they conclude that the original figures were wrong because they didn't take into consideration the expropriation, the amount of money was needed to pay expropriation of the plot of lands where the project has to be built. So it was almost 1/3 more of the already very significant cost of the project. And even if we have to assert that still in 2019, the Malaysian area was quite divided. There were part of the government that were in favor of the total cancellation of the project, and whilst the other were more open to maybe rediscuss or to renegotiate. Then the Chinese position we have to examine. The Chinese position was very tough, was very uncompromising. The Chinese, this is the most difficult part to reconstruct, because There are official statements, but came out at a later stage. So this is based on the comment of a journalist with the ties with the Chinese embassy. I face the same problem of other that involved in the research and mediation to actually find reliable sources to indicate. However, it seems that the Chinese were talking commercial. That's the expression that the journalists use. If you breach a contract, you have to pay 20 billion in compensation, and we don't care about any other sort of consideration. And originally, the approach of the Chinese was very tough. So the Malaysian government had to start to reconsider his position. And it's interesting to quote official statement of the new prime minister that say the PH government was faced with the choice to either renegotiate or pay cost of termination of 21 billion with nothing to show. So they decided to negotiate. So that's the first point. They decided to find, the point was to find a good negotiator. And I think that's the most interesting choice the Malaysian government made, was to choose a very experienced businessman who had certain tie with the Chinese establishment. And so this party was well accepted from the Chinese part, and this led to a sort of opening from the Chinese. That also on the Chinese side, what happened is that they start again to, on their turn, they start to reconsider their position and then send a first signal of opening towards the renegotiation of the terms of the project. And the People's Republic of China ended up signing a signal that it was going to open negotiation, taking in consideration the specific aspect of the situation. The point is, what happened is, and this, to my view, is very important for our specific case. It is at a certain point, the National Development and Reform Commission, representing the Chinese State Authority, stepped in and put the priority of the Chinese state-owned enterprise in the right order. It's clear that this railroad is an important piece of the Belt and Road project, but it's not a whole project. So to have a negative publicity on a certain problem may have represented a problem for the Chinese government that is already under accusation of this debt trap diplomacy in Africa or in Pakistan and other places of the world. And so they push the state-owned enterprise to seek an agreement with the Malaysian government. On April 2019, as you can see, again, are the MLR and the CCC. So again, the two state enterprise, there are negotiation at the level of the government level, but again, there is no treaty at the end between the two governments. It's just the state-owned enterprise. And they reduced significantly, without entering the detail of the figures, by 1/3 the overall cost of the building. And perhaps the most important victory of the Malaysian side was to obtain a 50-50 ownership basis in the managing of, in the owning and the managing of the railroad. This is very important because on one side, the reason for the Chinese party was of building this huge enterprise, building this railroad network was mainly strategic rather than economic. But if the economic risk was entirely put on the Malaysian side, this would have put Malaysia really at a disadvantage. This fact of sharing the managing of this railroad puts a part of the commercial risk of the enterprise on the Chinese part that is also is richer and more experienced. And so this is pretty good concession that they obtained. They improved, some technical support was granted, and the share for local contractors was increased from 20% to 40%. So that's positive. My question for the question that remains partly an open question to me is this lesson we learn from this very, I found it a very interesting case study that I learned through being part to this committee, is it exportable? Is there any lesson that can be transposed outside the specific context of the Belt and Road Initiative? Because I was in this subcommittee of the Belt and Road Initiative, so it was very interesting to me to tell you something about this. Can we use this outside? Well, to my view, it remains a great question mark, because it's very important to understand that both entities that signed this new agreement were almost entirely state-owned, and so it's clear that if the government has the control of the company, control the board of directors, control the shares, control everything, at the end the enterprise is very linked to the foreign politics of the government. So I doubt that if also the Exim Bank that was financing the largest part of the project and probably had to bear the heavy cost was also state-owned. So we have to consider I wonder if a private bank borrowing money on a private market would be able to be so generous, or if the negative publicity that could affect the government would have mattered to them so much to give such generous concession to the other party. So in this point, a last thing, one thing that perhaps it could be taken away, that's quite a very general remark, it's not surely a new discovery of mine, but I find it quite interesting, is in a sensible situation, the Malaysian government was clever enough to choose somebody that was really acceptable to the other party and to avoid to go out to a direct confrontation with the largest military and commercial power in its own region. So that's something that is quite a good point. That's a general remark that could be a good point. And with this, I conclude, and I thank you very much again for the invitation and for your attention.
Thank you. Thank you, Julia, for describing this case study. We'll comment later, and we'll try to give an answer to your questions. Now,
you have to change it very often anyway, because it's like every slide is just 1, 2, 3, 4. So it's going to be so quite often.
Open it and I'll leave you.
Okay. Okay. No, that's perfect. I just did not want to bother you because, like, I put 1, 2, 3, so it's going to be long. No, that's fine. That's just send me the two bash.
ready?
Basta che clicco qua. Basta che clicco il mouse.
So now the third speaker, ready?
Yes.
Giovanni Chiapponi from the University of Florence will speak of mediation in the field of climate disputes. It's particularly interesting to me because I've taught climate change law, and so I'm particularly interested in hearing something about it.
Thank you, Professor, for giving me the floor, and a big thank you to the organizers of the conference, Professor Forlati and Professor Porsche, and another big thank you to Professor Lopez-Peña for the fruitful discussion she had with me while I was preparing this presentation. Maybe I shall exempt you from any responsibility on what I'm going to say, but let's see later. Then, so my contribution, as you said, the focus is on mediation for settling climate disputes between individuals and states. And so the goal of this presentation is to explore the European and international standard on the cross-border enforcement of mediated settlement agreements between individual and states in the area of climate litigation. So in particular, the outcome of this analysis is to determine whether and how this type of settled agreement resulting from mediation can be recognized and enforced across the world. So let's have a look at the structure of my presentation. So first of all, I will start with a short introduction on the institutional and the European international framework on mediation. I will then move on the issue of the cross-border enforcement of mediated settlement agreements between states and individuals. Then third, I will assess the impact of the Singapore Convention on climate litigation between individuals and states, and I will finally conclude with some remarks on the future of mediation, and in particular on the prospect of this Singapore Convention. So first of all, we can start by saying that mediation is becoming more and more attractive as an alternative dispute resolution mechanism for settling international commercial disputes. So far, the institutional, European and international framework on mediation in civil and commercial matters can be summarized as follows. First of all, at the European level, we have Directive 2008-52 on certain aspects of mediation in civil and commercial matters, the so-called Mediation Directive. And then if we look at the international level, the two more relevant instruments are the following one. First, we have the UNCITRAL model law on international commercial mediation and international settlement agreements resulting from mediation, which is designed to assist states in reforming and modernizing their laws on mediation procedure. And then we have the United Convention on International Settlement Agreements resulting from mediation, the so-called Singapore Convention, which will be analyzed later in this presentation. So it is against this backdrop that in my presentation, I will address the topical issue as to how mediated settlement agreements, and more specifically, agreements settled between individuals and states, can be enforced cross-border. Indeed, ensuring an efficient framework for the cross-border enforcement of this agreement is crucial for encouraging mediation as an alternative dispute resolution means used instead of litigation and arbitration. So bolstering enforceability of such agreement across borders promotes finality in settling cross-border disputes, as it reduces the possibility of parties pursuing duplicative litigation in another jurisdiction in order to enforce their agreements. So let's look at the cross-border framework on cross-border enforcement of mediated settlement agreements, first at European and then at the international level. So on the one hand, at the European level, we have the Brussels 1 bis regulation on jurisdiction and the recognition and enforcement of judgment in civil and commercial matters. In particular, Article 59 of this regulation regulates the enforcement of court settlement which have been approved by a court of a member state or concluded before a court of a member state in the course of proceeding. Notably, it provides that a court settlement that is enforceable in the member state of origin shall be enforceable in the other member states without a declaration of enforceability being required. So we see that this definition excludes from the scope of the regulation out-of-court settlements, which are, I would say, the most developed in the international arena to settle international commercial disputes. So it follows that the impact of the Brussels 1 bis regulation on the cross-border enforcement of mediated settlement agreements across the EU is very limited, as it refers only to in-court settlement agreements. So, on the other hand, we have the 2018 Singapore Convention, which is a multilateral treaty that provides a legal framework that facilitates the circulation of international mediated settlement agreements. So the rationale behind the drafting of the convention was the acknowledgement that international settlements are more difficult to enforce than domestic ones, and this was said to disincentivize the use of mediation for cross-border disputes. The convention thus establishes an efficient framework where mediated settlement agreements can be enforced in a signatory state if the other party fails to comply with the settlement, obviating as such the need to start over in litigation or arbitration. Let's look at Article 1 of this convention. Article 1, which provides that the convention applies to an agreement resulting from mediation and concluded in writing by parties to resolve a commercial dispute, which at the time of its conclusion is international. So from this definition, we can derive some constitutive elements which allow us to identify agreements under the scope of the convention. So first of all, we have the definition of mediation. Article 1 states that the convention applies to settlement agreements reached in a mediation process. And then it is the convention itself, in Article 2, which provides its own definition of mediation, which requires the existence of three constitutive elements. So a dispute, the intention of the parties to seek an amicable settlement, and an independent and impartial third party neutral, the mediator, that assists the parties to reach a consensual settlement without imposing it. So we see that this definition excludes cases where the judge acts as a mediator, and this is in order to avoid situation in which the judge could pressurize the parties. Then the second element refers to the in-writing requirement. Indeed, Article 1 states that the agreement must be concluded in writing, and it is completed in this regard by Article 4, which affirms that the agreement should be signed by the parties and accompanied by evidence that the mediation took place. Then we have the third element that is the international element, and this element is understood in the sense that at the time of the conclusion of the agreement, and this is again defined by Article 1 itself, in the sense that the agreement requires that at least two parties to the settlement agreement have their place of business in different states, or the state in which the parties to the settlement agreement have their place of business the state in which the parties to the settlement agreement have their place of business is different from either the state in which a substantial part of the obligation under the settlement agreement is performed, or the state with which the subject matter of the settlement agreement is most closely connected. So this was I was quoting Article 1. And so we can see that the internationality of the settlement agreements is determined by either the location of the parties at the time when the settlement is concluded, is reached, or for the presence of a foreign element in the agreement. Let's now move to the fourth element, which is the more relevant one regarding our presentation of today, and which requires that the agreements shall resolve a commercial dispute. So the term commercial dispute is deemed to refer to conflicts that arise between two businesses or traders which are operating within the remit of their profession. So in particular, regarding the word commercial, the UNCITRAL model law that we quoted before provides an illustrative and open-ended list of relationships that might be considered as commercial in nature. So we see that the UNCITRAL model law says that the term commercial should be given a wide interpretation so as to cover matters arising from all relationship of a commercial nature, whether contractual or not. So relationship of and then we have a list which say that relationship of a commercial nature include but are not limited to the following transaction that we can actually read in the text, but I'm not going into it. I'm just saying that there is a lot of flexibility, and this is an open-ended list. But this is to say that the term commercial should be given a wide interpretation so as to cover matters arising from all relationship, I would say, all relationship which can involve investor and state matters. In particular, in this regard, there has been some discussion as to whether the term commercial extend or not to investor state matters. And according to the definition of the model law, it has been argued in academia that it clearly emerges that state may be parties to mediated settlement agreement under the convention, and this is further confirmed by the fact that at the drafter of the Singapore Convention intended to exclude the coverage of investor-state dispute resolution outcomes, they would have explicitly provided for it. So there is one last exception that is provided for in Article 1. We should look at it. It states that the convention applies to investor-states dispute in the absence of a reservation to the contrary. So, in particular, Article 8 provides for a permissible reservation allowing parties to the convention to declare that the convention does not apply to international mediated settlement agreement of which it is a party or of which its government agencies or any person active on behalf of its government agency is a party. This article does not contain any reference to state-owned companies, which then open the question whether these companies can be included in the declaration. It has been argued in academia that the provision was not meant to enable state to exclude state-owned companies from coverage under the convention. However, some states might eventually include in a broad definition of government agency an exclusion. So we can now move to the core of my presentation, which is to assess the impact of the Singapore Convention on climate litigation between individuals and states. So nowadays, states and companies are more and more bound to comply with European and international rules on climate, such as the obligation to ensure and fulfill human rights and protect the global environment. And in case states and companies fail to comply with the latter obligation, these may entail damages to individuals, like, for example, not reducing gas emission, may have temporary and permanent effects on people and the environment, leading as such to relevant violation of human rights. And as a consequence of this violation, individuals could eventually seek a remedy aimed at restoring the damages they incurred and seizing the liable states and company alleged violation. So, other than initiating legal proceeding, which is certainly the most developed method to solve dispute in the field of climate litigation, as we can see, for example, against the liable state, we have a lot of case law, for example, the Urgenda case, or against company, we have the current pending Lula case in Germany. But other than initiating legal proceeding, what we can say is that for an interesting option for individual having suffered the human rights violation deriving from state or company failures to comply with international climate duties could be to rely on alternative dispute resolution method such as mediation. Mediation has indeed a lot to offer, so flexibility both in terms of time frames and procedure, confidentiality, affordability and cost effectiveness, as this is generally less expensive than litigation, and the benefit of full party autonomy from the initiation of the process up until its termination. So agreeing on an amicable solution allows parties to preserve long-term business and personal relationships and facilitate the administration of their ongoing and future transactions. So if we think specifically to the field of climate litigation, where the case law is constantly evolving, parties when considering mediation should also take into account the advantage, this is mainly for state, and disadvantage, mainly for individuals, that concluding a mediated settlement agreement may prevent the establishment of a settled case law, which may have important implications for future similar disputes involving the same parties. So, so far, climate litigation between states and individuals has been mostly domestic, with no need to enforce judgment cross-border. So, similarly, we can say that the enforcement of settlement agreement in climate dispute between individual and states is generally possible only under the law of the responsible state which participated in the mediation process. Indeed, there would be no reason for seeking the enforcement of such agreement abroad, as the goods to be seized are located in that state. For instance, a mediated settlement agreement, providing that Belgium did not comply with its positive obligation to take reasonable and suitable measures for preventing climate change and violated as such human rights, would hardly be enforceable outside of the Belgian territory where the goods to be seized are located. So in this regard, it's not relevant looking at cross-border enforcement of this agreement. But on the other hand, what can be interesting is the cross-border enforcement of settlement agreement mediated and concluded between individual and states in climate litigation, in particular concluded between individuals and state-owned enterprises, whose activities are influenced and controlled in different ways by states. So, for instance, states can exercise different forms of economic influence over various multinational enterprises, and due to the state business nexus, such enterprises, irrespective of their formal characterization in the national legal orders, may be defined under European and international law as public enterprises. So their conduct under certain specific conditions set out by European and international law can be attributed to states. So the conditions set out are mainly set out by the Court of Justice case law and on the draft article on responsibility of states for international wrongful acts and in the OECD guidelines on corporate governance and of state-owned enterprises. So we see that in this field of climate litigation, enforcing in a foreign country an agreement settled with a state-owned enterprise could represent for victims of human rights breaches a further necessary steps toward effectiveness of justice, of access to justice and redress. So I'm going to conclude with an example which will allow us to see the interest of extending the application of the Singapore Convention. So we can imagine a case where an Italian state-owned company operating in Madagascar through a subsidiary which benefits from funds from two state-owned development banks located in Finland and Belgium. So let's imagine that some Italian, Belgian, French, and Malagasy association contested the Italian state-owned company that it did not comply neither with the climate commitment provided for in the 2015 Paris Agreement, nor with the OECD guidelines for multinational corporations. So this conduct violated numerous human rights of individuals affected by companies' activity with temporary and permanent effects on people and the environment. So let's imagine that the association asked the company to cease its operation in Madagascar and aims at obtaining compensation damages from the company for the alleged violation of human rights. So against this backdrop, the parties might use the OECD mediation service. So the Italian state and the OED company and the association might conclude an agreement, for example, before the Italian OECD national contact point. And according to such agreement, the company shall cease in operation in Madagascar and pay compensation for the damages caused to the individuals. So this example shows that going further, we can say that one may wonder in this example about the possible application of the rules of the Singapore Convention of Mediation, in particular if parties seek enforcement of the mediated settlement agreement in a country other than Italy, where the mediated settlement agreement has been concluded. For example, if parties aim at enforcing this agreement in Belgium, Finland, or Madagascar. So we can say that this example shows that the application of the Convention of Singapore would grant a mediated settlement agreement direct enforceability in other countries without parties having to go through a procedure before national courts. And this lead us to see the limits and benefits of the Singapore Convention. So first of all, we can say that in this case, the Singapore Convention would, ratione materia, in principle be applicable to the mentioned case. However, there is a limit to overcome for giving full effect to such instruments, which depend on the low number of ratification. So far, the Singapore Convention has indeed 55 signatory states and 18 ratification, and no EU member state nor the EU has signed the convention yet. So it is against this backdrop that I may argue that the Singapore Convention, as long as more countries will sign and ratify it, could reach its full potential and become a pivotal instrument for the cross-border enforcement of mediated settlement agreements in climate disputes between individual states, and of course also in private climate disputes, where the convention would have even a wider impact, provided that litigation between individuals and companies is even more common. With this, I conclude my presentation, and I'm sorry if I talked a bit too much, and I want to thank you everyone for it.
Thank you, Giovanni. You showed us a peculiar path, new path in the field of climate litigation. My first reaction is that probably mediation works when damages are sought. I'm not so sure when other claims are, when different claims are on the table. Usually the claims are based on lowering the emissions and so things like that. Maybe it's more complicated, but
yes, I fully agree with you. I would say that I would say that this kind of this convention may help more the restore of damages than the seizing of certain conducts of states. But the example that I took and was, I would say, a real one, that it's pending. I mean, more or less a real one, with some peculiarities that I put into, that is currently pending before the national OECD contact point between some company, some association and.
okay, but let's hear from the audience. We have 15 minutes left for debate, for questions.
Hi. Hello, this is Amy Porges. So I have questions mainly for Facundo and for also for Julio. So Facundo, what you're pointing to about the consultation process is that I would say the important point is that every investment dispute starts with some actions by the government, which the investor is rightly or wrongly convinced are deeply unfair and financially really damaging, because nobody brings these disputes randomly. They're expensive, and they involve really disrupting your relationship with the government, which is the government of the host state, which is always not something you think about lightly. So how, and I guess what you're saying is that the consultation process is possibly the first point at which the facts of the claim are presented to the lawyers of the government, and also to those parties that are the lawyers who then have a connection with people in the government who can do something to fix the problem. So how often, so the investor could be asking for either money damages, or they could ask for some kind of practical change that would make it possible to stay in that country and preserve its relationship with the market and with the government. Just saying. So how often do you think settlement demands involve money? And how often do you think that they involve a change on the part of the government? And does this change over time? Next. And do you, because as I've also observed, there's also a kind of a dominant point for settlement during investor state cases, which is right after if the state loses on jurisdiction. I mean, because at that point, the lawyers and the government are really convinced that they're going to lose, that the facts are awful, and the tribunal will really make them pay. So do you think that the shift of demands between money and change of conduct shift over time during the course of a dispute, between the consultation process and that magic moment after the state loses on jurisdiction? Also about transparency. Do you think there's a lot of transparency in NAFTA and USMCA because, the kind of culture that the US has in particular? Do you think that this has led to an excessive focus on NAFTA and USMCA in relation to settlements? Do you think there's too much focus on NAFTA and USMCA in the writing about dispute settlement investor state generally, as composed to BITS? Also, do you think the actual settlements results are comparable under BITS and under NAFTA and USMCA, or are they just more visible? Okay, again, about change of action, change of conduct. This is really what's really interesting to me about the Malaysia case is how they were able to end up in a solution that involved they started out with a demand for money, and they ended up with a practical solution, which was probably more constructive. But the next question is, and in fact, this could be more durable than a demand for payment, because in the end, if you have a big award, there's always the question of whether the government will actually pay. And sometimes that doesn't happen. To what extent do you think this solution is going to be durable? What happens the next time there's an election in Malaysia and the Malaysian government says, why do we have a Chinese entity as a half owner of this railway in Malaysia? Okay, end of the questions. Next.
Can I? Okay. So I have two questions, one for Facundo and another one for Giovanni. So among your suggestions, you were mentioning the need to draft more detailed provisions on negotiations and consultation, and more specific regulation on consultation. So my question is, did you find some missed opportunities in which ADR in this context was not activated because of the lack of provisions? Or even in cases you mentioned that there was settlement prior to arbitration, did you feel that the lack of more detailed provisions could have played an important role? So this is one, and the second one for Giovanni. Well, I thought it was very interesting, the discussion on the Singapore Convention, but it still looked to me, I had the impression that it was mostly theoretical, the application of this, right? And I was wondering whether you presented a case study at the end, but whether you have concrete examples of settled agreements in climate disputes mediated between individuals and companies in general that could benefit from the Singapore Convention. And also, maybe we could envisage more concrete steps that have been taken already in EU norms in terms of ADR. For example, some regulations on environment, dealing with environment and dealing with sustainability that already provide for ADR mechanism. Did you analyze these ADR mechanisms and these norms? Would it be more feasible to think about about this than to envisage the application of the Singapore Convention? Thank you.
Was there another one here?
I did a study once for the late lamented ICTSD on WTO cases and settlements. Totally untransparent area, I hasten to add. But what's at stake is not directly money, of course. It's forcing the other state to change practice. And the striking part, to the extent I could tell, I called a lot of people to find out what had happened, is that there's, again, different stages of the process. And so the complaint, in effect, the request for panel is filed after consultations. Cases settled during consultations. It was a formal consultation period. Once the formal panel request went in, no. Then at the very end, you might settle once you've lost. And as I said, it took a lot of phone calls to find that part out. So it's very striking that the different timing, governments were willing to change at one point, another point, no. And so I was fascinated by your timetable. So it's worth thinking how those provisions for timetable affect settlement. So I found that quite interesting. Thanks.
Thank you so much for your presentation. I'm Giovanna Dinolfi from the University of Milan. I have a question for Giulio. To arrive at that settlement between the two companies, let's call them two companies, maybe was also because it's a question, curiosity would say, because of the dispute settlement clause in the contract they had concluded. I mean, which kind of dispute settlement process would have been activated without a successful negotiation among the two parties? So maybe I was asking myself, maybe both of them have softened their position not to go before a strong judicial or arbitral process with the final award that would binding upon the losing party. And then on Giovanni, I have the same comment that Alberto made, that is maybe this procedure could work in case you have claims that requires payment, reparation for damages. But in a classic climate dispute between an individual and the state, asking an agenda case, where what the claimant were looking at was a change of the domestic legislation. I mean, that would become, I would say, but maybe I'm wrong, less relevant, that mediation of climate change disputes between states and individuals. So it was just, I have the same comment Alberto's made. Thank you.
Was there anyone else? No? Okay.
Well, thank you, Emmy and Paula, for the very interesting questions. I will start with Emmy's question concerning the satisfaction you can have during consultation, whether the change of a measure of money. I would say that it depends on the case, and also it depends on the state involved. For instance, if there was an investment that was terminated, for instance, a contract terminated, at that point, I mean, you don't have other choice but to offer some kind of compensation in money, let's say. But for ongoing investments, it is possible to request other kind of measures. For instance, the continuation of a contract. And it depends. I said that it depends also on the state, because, for instance, in the case of Argentina, since the country normally does not have much money, it cannot offer money. So at the end of the day, perhaps it would offer a renegotiation of a contract instead of money. And if you see the practice of Canada, I think it's more common for Canada to offer compensation or money. Then you refer also to the stage of the proceeding and what happened once, for instance, there is a decision on jurisdiction. I would say that it is easier to ask for other kind of compensation apart from money at the beginning of the proceeding. But once the tribunal has decided it has jurisdiction, it would be difficult to offer some change in the measure. And I mean, the investor will go for the money, and I think at that point, perhaps the government, in principle, would not have the will to change any legislation. Then, concerning your question on transparency and why we focus, or perhaps I focus too much in NAFTA, for instance, at least for this case, it is because we have more information, because, as you said, there is more transparency in NAFTA. Although I would say this information is not complete, and I'm sure there are other cases that were settled and that we don't have that information. But I should say also that it is possible to bring some information from VIT's cases, and actually in some awards you have some awards include they are called awards of settlement. They include also the settlement reached between the investor and the state. So at some point it is possible to make also an analysis of the agreements reached in those other kind of disputes. Then concerning Paula's comment, I think one of the problems with the consultations in investment agreement is the lack of provisions for first. Second, on other situations that the provisions are not very developed. So at the end of the day, investors, they do not know what they should do in order to comply with the consultations. And third, this lack of consistency between the decision of investment tribunals produce that sometimes investors don't take this consultation requirement very seriously. And I would say it's not perhaps the responsibility 100% of the investor, but also of the tribunals, and I would add also because the responsibility also of the states, because it is the states who should improve these kind of provisions.
Thank you for both for the question I received. I will invert the order of the question because I think it's interesting to start with the answering the fact that the both contract that was signed originally are totally unpublished. I did my best to look for them, even on the ministry, on the parliament, Malaysian parliament. I did whatever I could. I wasn't able to put the end on the contracts. So that is an interesting question. I assumed that the most probable form would be arbitration. I think it's quite common to include a dispute settlement clause, and so I think then international arbitration would have been probably the easiest solution the party would have start. Anyway, this leads us to the second point. Even if the Malaysian state would have lose, even if would have paid, that would have certainly perceived like a national humiliation from the Malaysian people, because it's 1 or 2% of their internal products. So if China wants to create and to develop this project, even this victory in court would have probably not been a very favorable outcome, also because China is like to develop other projects, and this would have throw a very dangerous, certain shadow or the overall project of the Belt and Road Initiative, and so many other countries would have been much more careful before entering into contracts with China. Anyway, the overall mechanism in China of the Belt and Road Initiative is very, very not transparent. We know that exist at least 5 mediation centers that are linked through a quite complicated mechanism for ensuring mediation, but there is not a general public framework of the Belt and Road Initiative. There is not a general common settlement clause. The only thing you can find is that there is a center in Beijing or in Shanghai that would take care of the mediation. This is really part of the Chinese culture of trying to mediate to that, the dispute also with foreign investor. They bring the investor in different ministries until the investor accept a mutual accepted solution. It's deeply rooted in the Confucian tradition, and I read an article that's very interesting on that. The question is durable. That's a very good question to my view. It's of course, if a new very nationalistic government takes place and say now perhaps our most strategic infrastructure is 50% owned by China, and we want perhaps create new ties with the United States, this could create us a problem. So in general, I would say that as a small country, it's considered a very positive attitude to not create sovereign risk, so to respect your engagement. So I think this could be the only answer I could give to my view. Of course, when you negotiate with the state, also political elements are involved, and that this represents a risk then that cannot be underestimated. Thank you for the question again.
Not only Malaysia. Please, Joanne.
We'll learn to close everything before. Okay, thank you very much for all your questions and comments. And I have to say that basically all the questions that you raised are also my concern, because I started really to focus in this topic for preparing this presentation, and I also basically had the same question. So regarding starting from the first question regarding the theoretical character of the convention, yes, of course it is theoretical, and it's also what I was saying at the end, because there is a low rate of ratification, so that is a problem. And But I see anyway, like the possibility that many parties ratifies, because in any case there are many states that signed it. So at that point, this step can be done, and there are also many relevant states like China, like the US. So at this point, it can really have a big potential if these parties are going to sign. And also regarding the EU has considered the accession to this convention, but the problem apparently is that there is a fear that parties abuse of this process. So that's why basically the EU is not acceding, but is still considering, but maybe not in such a concrete way. So and this also relates to the fact of more concrete proposal in the EU. In this regard, regarding mediation and cross-border mediation, yes, it can be easier probably to have a cross-border enforcement within the EU, like the same system of the Brussels von Bis regulation. But again, I think that there would be the same problem. There would be the same problem of fear of abuse of parties in this kind of process. And also the other, I mean, I'm not so sure about this, because also in mediation, this convention tell us that there is no seat of mediation. So given the fact that there is no seat of mediation, a mediation can perfectly be concluded in Singapore or whatever. And so at this point also circulation at the EU can be less relevant than around the world. And also if we consider the field of climate litigation, most of the activities by these companies are probably carried out in Africa, in Madagascar, or other, I would say, other African countries. So there can be probably more concrete proposal, but maybe not on mediation, but on other ADR methods and means. Regarding a concrete example, no, I don't have any concrete example of of settlement mediated agreement between individual and state-owned companies. But what mainly raised my attention is the fact that on the OECD website, it's really, there is a page full of cases that are really day by day, because it's really, it's plenty of cases that are brought before this OECD national contact point in order to reach a mediation between these actors. So still, we do not have any concrete example, but I think that even this ongoing mediation can be an example of what we can maybe reach in the future. And finally, to conclude on the last comment, I fully agree on it that it's mainly for reparation of damages. I don't see how state can seize some kind of activities like gas emission or whatever, like Urgenda, with mediation. But it's here that I think that it can be interested for states, so state-owned companies or whatever, to agree on it, because like if they agree maybe on paying some damages, they can continue the activities. So this can be on I would say a bit on the other side, that can be kind of I mean, I'm not sure this is going to happen. Of course, probably there would be the other party that would not agree on it, but still that can be if we have to agree and on an amicable solution, we can find some
Why not?
way.
Okay. Thank you all. I think now we can close our meeting. Again, many thanks to all the speakers, to all the participants, and a special thanks to Serena for organizing all the day, and the University of Florence for hosting us. I don't know if you want to say something or not.
I will just thank you, all those present in person here and all those present online. If you are interested in ADR, maybe you could consider joining the committee. We are always eager to, have more people involved. But even outside the committee, I think the discussion and debate and interaction between academics and practitioners will be fruitful in the next years. And I thank you again for engaging with us and for these very fruitful discussions today. Thank you and goodbye.
The distinction between administrativity and jurisdiction is something very tricky.
Yes, yeah, and it depends also in the right the wording of the provision also. Yeah, it's different. Yeah.
It's an invention of
Yeah.